defendant is present. Everyone please be quiet. I've received a copy of the final instructions and penalty proceedings. Have both sides had the opportunity to review the most recent revised instructions? State?
Yes, Your Honor.
Defense?
Yes, ma'am.
Are there any additional corrections, amendments, or additions as prepared?
From the state, the only thing is, Judge, if you look at page 20, I think also, I have pages 20 through 23 corrected so that the rule for deliberation is now at the top of the page. I'm not sure how that happened last night, but also I think we're going to print out weighing the evidence. We'll have the correct.
Okay,
It
so
won't be under the first
what
line.
I'm going to do then is I'm going to put my packet right here, and if you would just switch out
Sure.
whatever needs to be switched and do the same for the defense, otherwise I don't want to get them mixed up, please.
No problem.
Charlene. Yeah, you can make this. Just handed me. This is the final copy that I'm going to read to the jurors. Is there any objection? Please let me know now because I'm going to have my assistant make copies.
Oh, for everyone? Or just for us?
Well, I was going to have her make a copy for the court reporter.
Oh, okay.
But if I don't want to make like 40 copies right now, we can do that. Well, if you need extra copies, we can do it while I'm reading the instructions.
I don't need an extra copy. Can I just come and look at the formatting on yours? And then the substance of mine is the same, I think. It's just the formatting is different.
Sure.
I don't need another copy. Thank you.
Sure.
Judge, just so everyone's on the same page about this, literally, Aaron, Mr. Savitsky will put it on the screen, and as you're reading, he'll flip the pages.
That would be great.
Okay.
Thank you for doing that.
You're welcome.
It looks good.
You know, I mean, there's something I didn't like about it, but I'll see. Aaron said that his didn't show it that way.
Because it's on hers, yeah.
I just like
formatting issue that Aaron appears to have fixed on the version that's gonna be shown on the screen. So
Okay.
that's fine, and then after you're done reading them, they go back, we can print this copy out to give them, because I prefer them to have this copy than the one that you have right now. But everything else is the same, it's just one word on one page that got moved back.
So I don't have to read it differently?
No.
I'm not looking at it right now because I gave it to them to make copies.
Okay.
It
no.
doesn't affect what the words that are
No.
gonna come out of my mouth,
It
just the
doesn't.
way that they're
Yes,
placed on the page.
yes, ma'am.
Okay. Thank you.
But I can see why. Buddies? Is it good size? Well, you can, yeah, just as long as you can see it,
Aaron, is that a yes?
yes.
You've never been in my division. I had a coach in high school that if you said yeah, you would be in big trouble. So it is in my brain, always yes, not yeah.
Apologies, Your Honor.
What's that?
Yes.
And of course, it's totally your prerogative, but if you wish to read the verdict forms to the jury, the state's suggestion, and the defense agrees, you could read count 1 and count 9, and that would, you wouldn't have to read all 17 of them. Count 1 has 5 aggravators for that victim, and count 9 has the 7 aggravators. So
We talked about this yesterday, didn't we?
yes, we did, but I don't know if you just made a decision or not, so I just wanted to bring it to your attention, and whatever you think is best.
The adults who are employers of the school, Aaron Weiss, Christopher Hickson, and Scott Beagle, have 2 additional aggravators that the minor students do not.
Yes.
They have 5, the adults have 7.
That's correct. Yes, ma'am. And the first one that comes up as far
Is
as
count 9.
7 is count 9.
Okay. That's fine with me if everyone's in agreement. Okay, we're lining the jurors up. I want to reiterate that for the most part, everyone has been great, including lawyers, staff, guests, but please continue to be very, very quiet. No talking unless absolutely necessary, and we would prefer that people not get up and go out and come back in unless it's very important while I'm reading the instructions, because I want the jurors to be able to really concentrate and be able to hear and understand. Thank you. present. Everyone else may be seated. Ladies and gentlemen, good morning. Please listen closely to the instructions that I'm about to give you. Members of the jury, you have heard all of the evidence and the arguments of counsel. It is now your duty to make a decision as to the appropriate sentence that should be imposed upon Nikolas Jacob Cruz for each of the 17 counts of first-degree murder charged in the indictment. There are two possible punishments. 1, life imprisonment without the possibility of parole, or 2, death. Each crime and the evidence applicable to it must be considered separately when deciding an appropriate sentence for each count. Also, a separate verdict must be returned as to the appropriate sentence for each of the 17 counts of first-degree murder. A decision as to one crime must not affect your decision as to the other crimes charged. In making your decision, you must first unanimously determine whether the aggravating factor or factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. Aggravating factors. The aggravating factors alleged by the state are: number 1, Nikolas Cruz was previously convicted of other capital felonies or felonies involving the use or threat of violence to another person. The court further instructs you that where a defendant is convicted of multiple murders arising from the same criminal episode and involves multiple victims, the contemporaneous conviction of murder in the first degree or attempted murder in the first degree as to one victim may support the finding of the prior violent felony aggravator as to the murder of the other victims. A, the crime of first-degree murder is a capital felony. The crimes of murder in the first degree of count 1, Luke Hoyer, count 2, Martin Duque Enquiano, count 3, Gina Montalto, count 4, Alexander Schachter, count 5, Elena Petty, count 6, Alyssa Alhadeff, count 7, Nicholas Dorette, count 8, Helena Ramsey, count 9, Christopher Hickson, count 10, Carmen Shentrup, count 11, Aaron Feiss, count 12, Scott Beagle, count 13, Meadow Pollock, count 14, Carol Loughran, count 15, Joaquin Oliver, count 16, Jamie Gutenberg, and count 17, Peter Wang, are capital felonies. B, the crime of attempted first-degree murder is a felony involving the use or threat of violence to another person. The crimes of attempted first-degree murder of Ashley Baez, William Olson, Kashava Magnapuram, Justin Colton, Alexander Dorette, Genesis Valentin, Daniela Menescal, Samantha Grady, Samantha Fuentes, Isabel Checker, Samantha Mayer, Benjamin Wickender, Madeline Wilford, Marianne Kavachenko, Stacy Lapel, Anthony Borges, and Kyle Lamont are felonies involving the use of violence to another person. C, the crime of attempted battery on a law enforcement officer, Sergeant Raymond Beltran, with a deadly weapon, filed under Broward County case number 18-14129, CF10A, is a felony involving the use of threat or violence to another person. The crime of battery on a law enforcement officer, specifically Sergeant Raymond Beltran, under the same case number, is a felony involving the use or threat of violence to another person. The crime of depriving an officer, Sergeant Raymond Beltran, of means of protection, also under the same case number, is a felony involving the use or threat of violence to another person. This aggravator applies to all 17 counts of first-degree murder, all 17 victims. Aggravator number 2, Nikolas Cruz knowingly created a great risk of death to many people, many persons. This aggravator applies to all 17 counts of first-degree murder. Aggravator number 3, the first-degree murder was committed while Nikolas Cruz was engaged in the commission of a burglary. And a burglary is defined as the entering of a structure without permission or consent, owned by or in the possession of the Broward County School Board, and at the time of the entering the structure, Nikolas Cruz had the intent to commit the crimes of first-degree murder. Aggravator number 3 applies to all 17 counts of first-degree murder. Aggravator number 4, the first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime that's intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was pitiless, and was unnecessarily torturous to victims Luke Hoyer, Martin Duque Inquiano, Gina Montalto, Alexander Schachter, Elena Petty, Alyssa Alhadeff, Nicholas Jorette, Helena Ramsey, Christopher Hickson, Carmen Shentra, Aaron Feiss, Scott Beagle, Meadow Pollock, Carol Loughran, Joaquin Oliver, Jamie Gutenberg, and Peter Wang. This aggravator applies to all 17 counts of first-degree murder. Aggravator number 5. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. This fifth aggravator applies to all 17 counts as charged in the indictment. Number 6. The first-degree murder was committed to disrupt or hinder the lawful exercise of any governmental function or enforcement of laws. Now, this aggravator applies only to Christopher Hickson, Aaron Feiss, and Scott Beagle, who are the adults who were employed, working as employees at the time of the incident. It does not apply to the students. Aggravator number 6. Aggravator number 7 also only applies to the adult employees, not to the students. The victim was an appointed public official engaged in the performance of their official duties if the motive for the first-degree murder was related in whole or in part to their official capacity. For count 9, Christopher Hickson was an appointed public official engaged in the performance of his official duties if the motive for first-degree murder was related in whole or in part to Christopher Hickson's official capacity. Count 11, Aaron Feiss was an appointed public official engaged in the performance of his official duties if the motive for the first-degree murder was related in whole or in part to Aaron Feiss's official capacity. For count 12, Scott Beagle was an appointed public official engaged in the performance of his official duties if the motive for first-degree murder was related in whole or in part to Scott Beagle's official capacity. You have heard the evidence about the impact of this murder on the family and friends and the community of each victim. Luke Hoyer, Martin Duque Anquiano, Gina Montalto, Alexander Schachter, Elena Petty, Alyssa Alhadeff, Nicholas Dorette, Helena Ramsey, Christopher Hickson, Carmen Schentrup, Aaron Feiss, Scott Beagle, Meadow Pollock, Carol Loughran, Joaquin Oliver, Jamie Gutenberg, and Peter Wang. This evidence was presented to show each victim's uniqueness as an individual and the resultant loss by their death. However, you may not consider this as evidence of an aggravating factor. As explained before the presentation of the evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proven beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate on the form whether or not you find each aggravating factor that applies to each victim, whether it's been proven beyond a reasonable doubt. As I explained before, there are 5 aggravating factors on each of the students' verdict forms, and there are 7 on the adult employees. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility of parole. As such, your deliberations are complete at that time. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. Mitigating circumstances. If you do unanimously find the existence of at least one aggravating factor, and that aggravating factor is, or that the aggravating factors are sufficient to impose a sentence of death, the next step in the process is for you to determine whether any mitigating circumstance exists. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not the appropriate sentence in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are the following. Nikolas Cruz is a human being. Nikolas Cruz has neurodevelopmental disorder associated with prenatal alcohol exposure. 3. Nikolas Cruz has alcohol-related neurodevelopmental disorder. 4. Nikolas Cruz was not correctly diagnosed as a child and did not, therefore, receive the appropriate interventions at various stages of his life. 5. Nikolas Cruz was exposed to alcohol in utero. Nikolas Cruz was exposed to drugs in utero. Nikolas Cruz was exposed to nicotine in utero. Nikolas Cruz's birth mother did not obtain proper prenatal care. 9. Nikolas Cruz was 19 years of age at the time of the crime. 10. Nikolas Cruz's brain was not fully developed at the time of the crime. 11. Nikolas Cruz witnessed the death of his father. 12. Nikolas Cruz grew up without a father, raised by a single mother. 13. Nikolas Cruz witnessed the death of his adoptive mother shortly before the crime. 14. Nikolas Cruz lived with a parent who abused alcohol. 15. Nikolas Cruz's adopted mother was not forthcoming to medical and mental health and educational providers regarding his... Nikolas Cruz's adoptive mother was not forthcoming to medical, mental health and educational providers regarding his birth mother's use of alcohol, drugs, and nicotine during pregnancy. 17. Nikolas Cruz's adoptive mother was inconsistent with his medication regimen. 18. Nikolas Cruz's adoptive mother did not follow all of the recommendations of his medical, mental health, and educational providers. 19. Nikolas Cruz suffered food deprivation throughout his childhood. Okay, I'm going to just skip 20 for now and go to 21. Nikolas Cruz is immature for his age. 22. Nikolas Cruz struggled academically throughout his life. 23. Nikolas Cruz continues to try to educate himself despite incarceration and learning difficulty. 24. Nikolas Cruz was sexually abused by a trusted peer. 25. Nikolas Cruz has the following deficits or disorders or impairments. Developmentally delayed. Severe phonological delay. Memory deficits. Motor function delays. Neurological impairments. Social skill impairments. Adaptive functioning deficits. Executive functioning deficits. Central nervous system abnormalities. Independent functioning deficits. Cognitive deficits. Intellectual deficits. 26. Nikolas Cruz was diagnosed with the following during his life. Attention deficit disorder, attention deficit hyperactivity disorder, oppositional defiance disorder, reactive attachment disorder, learning disability, speech and language delay, pervasive developmental disorder, developmental receptive language disorder, conduct disorder, disruptive mood dysregulation disorder, impulse control disorder, anxiety disorder, antisocial personality disorder, and borderline personality disorder. 27. Nikolas Cruz experienced risk factors of antisocial personality disorder, including A, unstable or erratic parenting, inconsistent parental discipline, having 2 first-degree relatives, his mother and his sister, that exhibit antisocial behavior. 28. Nikolas Cruz was declared a vulnerable adult due to mental illness by the Florida Department of Children and Families. 29. Nikolas Cruz was bullied and ostracized by his younger brother and peers. 30. Nikolas Cruz lacked self-confidence and had feelings of inadequacy growing up. 31. Nikolas Cruz grew up in a verbally abusive household. 32. Nikolas Cruz has remorse. 33. Nikolas Cruz was a diligent and conscientious employee and has a good employment history. 34. Nikolas Cruz pled guilty and accepted responsibility for his crimes. 35. Nikolas Cruz has the ability to succeed in a highly structured and supervised environment such as Florida State Prison. 36. Nikolas Cruz exhibited appropriate courtroom behavior. 37. Nikolas Cruz is currently under the care of a psychologist and a psychiatrist in the Broward County Jail. 38. Nikolas Cruz was compliant with his medication regimen in the Broward County Jail. 39. Nikolas Cruz will be punished in prison and society will be protected. 40. Nikolas Cruz is loved by people who will continue to be present in his life. 41. The existence of any other factors in the defendant's character, background, or life or circumstances of the offense which would mitigate against the imposition of the death penalty. Ms. Curtis, can I just see briefly, and Ms. McGann? record. Read, I wanted to make sure that I was reading it correctly. Number 20 under mitigators is that Nikolas Cruz was medicated throughout his childhood. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravating factor or factors that you have unanimously found to exist outweigh or outweighs the mitigating circumstance or circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mathematical or mechanical process. In other words, you should not merely total the number of aggravating factors and compare it to the number of total mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the result of each juror's individual weighing process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I have said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factor or factors are sufficient to impose death must be unanimous. And your finding that the aggravating factor or factors found to exist outweigh the established mitigating circumstance must be unanimous. And finally, your decision to impose a death sentence must be unanimous. This process is spelled out in the form of questions, and when you finish question 1, you move on to question 2, so that it makes it a lot easier to understand the process of what do we do next. You will be provided with 17 forms. It's actually, each count includes a different victim, as you all know. And each verdict form for each count and or each victim is 4 pages. And you must fill out all 4 pages because, like I said, there are specific questions about the aggravators and the mitigators and the weighing process that you have to answer along the way. And there are also instructions on the verdict form that will show you when you need to move on to the next question or when you're finished. Again, you will be provided with 17 verdict forms to reflect your findings and a decision regarding the appropriate sentence for each count of first-degree murder. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. Weighing the evidence. When considering aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have the opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with other testimony and other evidence in the case? Had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony that he or she gave in court? Had the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe the person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. This witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not be influenced in any way by his decision. No juror should ever be concerned that the defendant did not take the witness stand or give testimony in the case. These are some general rules that apply to your discussions. You must follow these rules in order to make a lawful decision. You must follow the law as it is set out in these instructions. If you fail to follow the law, your decision will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Your decisions must be based only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of exhibits and evidence, and these instructions. Your decision must not be based upon the fact that you feel sorry for anyone or that you are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision. Your decision should not be influenced by feelings of prejudice or racial or ethnic bias. Your decisions must be based on the evidence and the law contained within these instructions. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. When you have reached decisions in conformity with these instructions, the appropriate forms should be signed and dated by your foreperson. Your decision must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and they are as follows. Now, I don't want to downplay the fact that there are 17 counts. It's just that there's 4 pages of forms for each of the 17 counts. But you have to carefully consider and evaluate each count as if you were only here to consider one count. In other words, you need to give the same time and attention to each count, each of the 17 counts. With that being said, I don't think it's necessary for me to read the verdict form for every count because as far as the students are concerned, remember there are 5 aggravating factors that are alleged for the students. So the students have one verdict form and then the employees have another verdict form. So I'm going to go over one of the students' forms and one of the teacher's forms so that you can see that there is a difference. But I'm not going to go over all of them because after I go over the first one, I think they'll be self-explanatory. So for example, it starts off, the state of Florida versus Nikolas Jacob Cruz, jury verdict form as to count 1, victim Luke Hoyer. Aggravating factors as to count 1, victim Luke Hoyer. The first question you have to answer is, we the jury unanimously find that the state has established beyond a reasonable doubt the existence of an aggravating factor. Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. And then you check yes or no. After you answer that question, no matter what your answer is, you move to question 2. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of an aggravating factor. Nikolas Cruz knowingly created a great risk of death to many persons. You answer yes or no. Regardless of your answer, you move to question 3. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Luke Hoyer was committed while Nikolas Cruz was engaged in the commission of a burglary. You check yes or no, and then you move to question 4. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Luke Hoyer was especially heinous, atrocious, or cruel. And you answer that yes or no, and you move to question 5. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Luke Hoyer was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And you check yes or no. Then you follow the instructions in bold, and it says, if you answer yes to at least one of the aggravating factors listed, so that's the 1 through 5, if you answer yes to any of those, please proceed to section B. If you answered no to every aggravating factor listed, do not proceed to section B. If you answered no to every aggravated factor, Nikolas Cruz is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole. If you answered no to every aggravating factor listed, please sign and date the verdict form, which is on page 4. So in other words, if you answer no to questions 1 through 5, you do not have to answer the remaining questions. You just sign and date the verdict form and indicate that you've reached a verdict. However, if you answer yes to at least one of the aggravating factors, you go on to section B, which starts on page 3. And it says, sufficiency of the aggravating factors as to count 1, Luke Hoyer. Reviewing the aggravating factors that we unanimously found to have been established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. And then you check yes or no. If you answer yes, you go on to section C. If you answer no, don't go on to section C. Simply sign and date the verdict form and indicate that a verdict has been rendered. If you do answer yes, you go on to C, mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes or no. And then you can see in the next section, it gives you instructions. Please proceed to section D regardless of your findings in C. So it's important after each section to read the next instructions to find out, do I go on or, do I not? D, eligibility for death penalty for count 1, Luke Hoyer. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established as to count 1. And you check yes or no. You go to the last page of, it says Hoyer at the top of each page, so you'll know which verdict forms go together in case they get mixed up. And it says on the top of page 4, if you answered yes to section D, please proceed to section E. If you answered no to section D, you do not proceed. Nikolas Cruz will be sentenced to life in prison without the possibility of parole. Please sign and date the verdict form. If you answered yes to section D, you move on to section E. And this is the last question. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, that the aggravating factor or factors are sufficient to warrant a sentence of death, and the aggravating factor or factors outweigh the mitigating circumstances, we, the jury, unanimously find that Nikolas Cruz should be sentenced to death. And then you check yes or no. Then the foreperson will sign and date the verdict form. So that is the example of the verdict form that I just went over with you that applies to what I'm going to refer to as the student victims. Okay? There's 14 of them that are identical as far as the form is concerned. Now, they're not identical people, and again, they should be considered separately and apart. The 3 adults have a different verdict form. And I'm going to go over the verdict form for Christopher Hickson to give you an example of what the verdict form for Christopher Hickson, Aaron Feist, and Scott Beagles look like. It starts off exactly the same. It has the name and the jury verdict form as to count 9. It indicates that it applies to Christopher Hickson. You'll see under aggravating factors, section A, the first 5 questions are the same. The only difference is that there are 2 additional aggravating factors that are alleged for the adults, and they are as follows. They're in questions 6 and 7. We, the jury, unanimously find that the state established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Christopher Hickson was committed to disrupt or hinder the lawful exercise of any governmental function or the enforcement of laws. Check yes or no. The adults also have number 7. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Christopher Hickson was an appointed public official engaged in the performance of his official duties if the motive for the first-degree murder was related in whole or in part to Christopher Hickson's official capacity. The rest of the form is the same. So that's the only difference, that there are 2 additional aggravating factors for the adults. The adult victims, again, Christopher Hickson, Scott Beagle, and Aaron Feist. It's set out very clearly in the instructions, but in case you're wondering what the difference is, it's the adults have a 5-page verdict form as opposed to a 4 because of those 2 additional questions. Otherwise, they are identical. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case, and you must not talk about this case in person or through telephone, writing, or electronic communication, such as a blog, Twitter, emailing, text message, or other means. Now, those of you who are going to be on the panel of 12 won't have the opportunity to do that because, like I told you yesterday, we're going to take your cell phones and only allow you to use them once a day to call home while being monitored. Those of you who in a moment are going to find out that you are our co-pilots, our 10 alternates, you also have to abide by these rules because we may need you. We don't know, and you are not going to be relieved of my order not to discuss the case until you receive word from my office that a verdict has been rendered, because it is still possible that we may need to substitute an alternate even after deliberations begin. So please remember, even though you're going to go home and you might tell your family members, I'm home because I was not on, I'm a co-pilot, not the pilot, right? To my one juror over here, whose name I won't mention, Mr. Delta, right? You're the co-pilot, although you still can't talk about it. It's a very big case. It's my favorite airline, that's why I remember. And that they're going to have to just wait. And they might be very curious, but you have to tell them, listen, I've followed the rules up to now, and a few more days is not going to hurt. So let them know you can't talk about it. Okay. Many of you have cell phones here in the courtroom. Like I've told you, you cannot bring your phones into the jury room. You'll need to leave your cell phones on the seat where they will be guarded by the court deputy while you deliberate. Now, the alternates are not going to be sequestered, and we're not going to take your phones. But it's going to be up to you to follow the same rules, except that we let you see your family and watch TV, although you still can't watch anything about the case or the news, and you might be so excited to know what is happening. If that's the case, you can call my office, and my assistant will either tell you, yes, there's a verdict, or no, there's not a verdict. She won't talk about it with you, but if you need that information, you can call her without violating any rules, and she'll tell you whether a verdict has been rendered. However, she is going to call you when a verdict is rendered to tell you you are no longer under the obligation not to discuss the case. Does everyone understand that rule? Please answer out loud. Yes. So if anybody, for some reason, gets your phone number or comes up to you in Publix, or, I don't know, a passenger on a plane finds out that our pilot here is serving on a jury, you cannot talk to them about it. You can't. You can talk to them about anything else, but not this. All right. Do not contact anyone to assist you in your deliberations, and these communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Remember, as I told you at the beginning of the trial, any notes that you took will be for your personal use. After you have completed your deliberations, the court deputy will deliver your notes to me. They will be destroyed. No one will ever read them. So if you find out you're an alternate, your notes have to stay here. We will not destroy the notes until a verdict has been rendered. We will keep them safe, just like we do every night when you leave them here. Your notes should be used only as aids to your memory And whether or not you took notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of any other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. During this trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. Prior to the start of deliberations, you will be shown how to operate the equipment in the jury room, which will allow you to view or hear any recordings. Firearms sent back to the jury room have been rendered inoperable, so they cannot be discharged. Not that you would try to, but just so you know and you feel safe, they cannot be discharged. However, if you wish to view any ammunition, we do not send back firearms and ammunition at the same time. If you wish to view the ammunition, let us know. We will have to remove the firearm and then allow you to view the ammunition. Also, if you wish to view any biohazardous material, which I believe is limited to DNA swabs, let us know. There's certain precautions we have to take before allowing you to perhaps touch those items. So put the request in writing, and we will do our best to facilitate that request. Ladies and gentlemen, I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I prefer one decision over another. If you need to communicate with me, send a note through the court deputy signed by the foreperson. If you have any questions, I will talk to the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law, and no one of us at all, has the right to violate the rules we all share. I'm going to repeat that because I sort of messed it up. No juror has the right to violate the rules we all share. Okay, at this time, our 10...
Your Honor.
Yes, thank you. Okay, ladies and gentlemen, just to be clear, under the mitigators that I read for you, between pages 11 and 12, because of the page break, one mitigator was separated into two. I did correct it, and I read it properly, but paragraph 15, moving on to the second page, is just one mitigator, and it reads as, Nikolas Cruz's adoptive mother was not forthcoming to medical, mental health, and education providers regarding his birth mother's use of alcohol, drugs, and nicotine during pregnancy. And we will amend that in writing. In other words, we'll give you a clean copy the way it's supposed to be printed before you go back to the jury room. Okay, at this time, the alternates who are not yet excused are going to be taken with the sheriff's office. The sheriff's office is going to take you to retrieve your belongings and to go to your cars like they do every day. Now, we give out certificates. I wish it was something fancier, but this is what the circuit does. And these are a little bit premature because you're not excused yet. But in the event that I don't see the co-pilots on this case, again, I want to have the opportunity to give you your certificate and thank you very much for your time and attention. There's also an order that's attached to the certificate which indicates you were here this week. Very much. It's nice to meet you. Ms. Walker. Thank you. All right, the individuals that received their certificates early, remember, you are excused. Thank you very much. Excused for the day, not forever.
On your chair.
Okay, so you all are it. You are our jury, our panel of 12. We will, I guess you can just keep your same seats, that's fine. If you would please put your cell phones on the ledge or on your seat. Okay, that's okay, that's okay. If it's in the jury room, if you have it with you, you can put it on your chair. If it's in the jury room, as soon as
We're going to check.
the other jurors are excused, we'll have you all go back and get your cell phone. The clerk, I don't know if you all have noticed, but she sits to my left and she's very, very good and very experienced. And she has reminded me to remind you all, the evidence is in, I don't know if you've noticed, but let's say, for example, there's a flash drive. It's going to be in an envelope, and it's going to have a certain number on it. What we ask is that if you wish to view a flash drive, say, for example, that you, when you're finished using it, that you put it back in the envelope that it was in. So in other words, because otherwise it will be very difficult for the clerk to have to go back and figure out what goes with what. Does that make sense? Yes? Okay. Is that good? Thank you. Also, this gentleman right here, who we call Ian, he's our tech genius here, and because I'm definitely not. But he's gonna go back and show you how to use the equipment just briefly. Please don't ask him any questions about the case. He won't answer. He's just gonna say you do this, you press this, and from what I understand, it's very self-explanatory and very simple to use. Also, the sheriff's office is going to give you menus as soon as you get back there, right? You already did? Have you already? How did you do it? I didn't excuse the option. Okay, so I understand you've all filled out what you want for lunch, so that's something to look forward to. You know, we're waiting for the alternates to clear out before we're bringing the rest. Okay. But you can be seated. You all don't mind, I don't think. Thank you, Judge. And thank you, Judge.
John,
Yes.
are we gonna have a list with all the exhibits and what they are?
Yes, that's a great question. The clerk typed a list, and that's going to go back with the evidence. You're welcome. There's also disposable gloves in case you want to wear. I mean, it's all in plastic. There's nothing dangerous. But if you don't want to touch things that other people have touched, mainly staff and so on and so forth, please feel free to use as many pair of gloves as you want. Yes. Are they gone? Thank you so much. Bring your notebooks with you. Okay, all the jurors have been excused to begin their deliberations. I'm sure you all have done this, but if you haven't, if you would please give the clerk a contact number so that we can get in touch with you if there's a question or a verdict. Other than that, we're in recess.
who was next to her, I believe she got sideswiped from the vehicle with some face damage, sorry.
And what was that girl's last name?
Knapp,
Knapp?
correct.
And your 7-year-old, what is her name?
Brinley,
Brinley?
correct.
Okay. Did you said that there was something with her tibia and
Fibula, correct.
fibula. Were they broken
They were
or?
broken. Yes, sorry, they were
Okay,
broken.
sorry. What did you do?
When, at that moment,
Right after the car went past your
Yep.
daughter?
so we leaped up. My daughter was crying. Many of the children were crying. We were trying to triage through and just seeing who was injured, and because it came that close. And again, I had looked down, kind of just assessed the situation a little bit. I had grabbed my daughter, had set her back on the curb a little bit, grabbed my oldest daughter, sorry, with the injuries. I grabbed my 3-year-old and set them there as well. And then at some point, a few moments later, got them. The other parents were lining up the children on the side of Clinton Street, on the side of the steaming cup, over in this area. So we eventually moved the kids back there.
Did you take Brinley that evening for medical care?
I did not.
Okay. How did you know that she had broken toes?
So there's a couple variables that came into play there. We did not know at the moment. I knew that she had a foot injury, and I did the typical dad thing, and I downplayed the initial injury. I carried her to the car. At the time of walking to the car, as a leader at Pro Healthcare where I work, I got an alert that the hospital was on lockdown. So my initial thought was to take her up to the hospital myself. Her acuity versus other victims laying in the road didn't warrant her waiting for an ambulance, and I could take her. At that time, when I got the lockdown notice on my phone, I decided to call my wife, who is a nurse practitioner in urgent care at the time, and I said, you're going to want to check this out. She was almost done with her shift anyways. We lived 15 minutes from the house, so we kind of convened there. She looked at it and decided to take her in at that moment.
So what foot was run over?
Her left foot.
When after the car drove over her foot, did she still have her shoe on?
She had, no, both shoes had come off somehow, but we lost one eventually, and then the other one, we found one.
Were you able to look at specifically the left shoe after the car went past?
I was.
Overruled. You may answer.
I did see the shoe later on. I think it was the next morning when we kind of had a chance to collect ourselves, and I recall seeing a tread mark across her shoes.
That be consistent with the tire mark?
It would be.
So the right shoe was unable to be located that night, correct?
Correct.
And the left shoe you did find, and that's what you took home with you?
Correct.
Now, you said that at the time you didn't feel that your daughter should be taken by ambulance because of what you were seeing. Can you describe to the jury what you were seeing?
Just mass chaos. Nothing like I'm a combat veteran. I've been around mass hysteria most of my career, and I had never seen anything like this in such a safe environment where it was just hysteria, screams, sirens everywhere, just and unknowing, are there other vehicles coming down? Like, what is actually going on here? So it was just an odd, eerie feeling for a very long period there.
And you had indicated you had seen a woman with plaid pants.
It seemed like pajama pants. Correct.
Okay. To the left of you.
Correct.
And did you see her being treated?
I saw many individuals standing around her. I know that one of the parents in our group is a physician. I believe she went on to render aid somewhere. I don't know if it was her or not, but I remember seeing a large presence around that woman.
And then, did you see any bodies to the right of your position?
Yes, that's where I saw two within which would have been part of the dancing granny group. I don't know if they were the grannies or not at the time. I just knew that there were two people laying on the ground.
So I'm going to show you what's been marked as State's Exhibit 15. and I'm just going to have it viewed in front of you initially. Do you recognize generally this map?
I do.
And do you see the position that you and your family were on November 21st of last year?
I do.
And do you see your daughter's name in a box that's above the word steaming cup?
I do.
And it's connected to a star that's orange in color?
Correct.
Is that the approximate location of where you and your family were when your daughter was run over? Your
That
foot
is.
was run over?
Yes.
May I publish it to the jury? It's previously been admitted.
You may.
Again, showing the jury State's Exhibit 15, if you can circle the orange star that's associated with where your daughter was struck. Thank you. And the approximate location that you observed the woman to your left?
Objection. Relevancy.
Overruled. You may answer.
And to your right? Next, I want to show you what has been...
Before you move on, I just want the record to reflect, because it wasn't screen captured, that the stars that he circled on Exhibit 15.
Actually, sir, before, so we can capture it, can you again circle the area where you and your family were?
Objection already.
Overruled. He may do it again since it was cleared before we captured it.
And then the area where you saw a body down on the ground to your left? And that's, you indicate that she had plaid pants, or it was a woman who had plaid pants?
Plaid, looked like pajama pants.
Okay.
Correct.
Do you recall what else she was wearing?
I don't.
Okay. And then to your right? Okay. And that would be the circles, if we can save that and mark it as 15. Hang on. Okay.
I think we're on B as well. It'll be marked as Exhibit B.
Thank you.
Sorry, 15B.
And where you marked the circle to your left, that was associated with the same place where there's a name Jane Kulik?
Yes.
Overruled.
And where you circled to the right, there are 7 different names under Dancing Grannies. Is that fair?
Objection. Leaving the
Overruled. You may
witness.
answer.
Yes.
Obvious.
Thank you. My
I'm sorry,
next,
I didn't hear the last part that you said, Mr. Brooks. Are you withdrawing that?
No, I'm not.
What did you say then?
I said it's pretty obvious from the picture. It's leading the witness.
All right, your objections noted. It's overruled. His answers may stand.
thank you. Sir, I'm next going to show you Exhibit 49, which is a video. I'm first going to have it played or put in front of you on your screen. If you can just let me know when you see a depiction on that screen.
I see it.
And you saw first couple seconds of that. Let me play it one more time and then ask you if you recognize that. Okay. I stopped it at 3 seconds. And do you recognize that area?
I do.
What is that area?
That's the corner right in front of People's Park where we were at the parade.
Okay. And you had said, is People's Park across from Steaming Cup?
Oh, sorry, Steaming Cup. Yeah, People's Park is directly across from Steaming
Okay.
Cup.
And that would have been the corner that you were located with your family?
At the Steaming Cup corner. Correct.
And do you see yourself depicted in this video?
I do.
Do you believe it accurately represents what you observed that day and what you did?
I do.
Okay. I would ask that Exhibit 49 be admitted into evidence and published to the jury.
Objection.
For the record, how long is the video clip?
It is 8 seconds.
All right, thank you. Exhibit 49 is received. Permission to publish is granted.
Thank you.
Objection. Noted for the record, Your Honor.
It is.
Okay, if we can play it starting at 0, going through the entire 8 seconds. Thank you. And you stated that you did see yourself in that video?
I did.
Going to the initial screen of that video, which would be at 0 seconds. Oh, if we can put it back up. Do you see yourself in, it's at 0 seconds, do you see yourself in this still frame?
Yes,
Can you circle, again, using the touch screen, where you are? And are you carrying Brindley?
I am.
Thank you. You can clear the screen. And next I would like to show just you Exhibit 50. And see if you recognize this intersection as it plays through for approximately 5 seconds. Do you recognize that as being the intersection you and your family were at?
Just forward of our location, yes.
So as you're looking at this, would it be, as you're looking at the screen to the left?
Objection, reading the witness.
Sustained is to the form of the question, if you would please rephrase.
Where would you and your family have been in relationship to this, where this video was taken?
To the left.
Okay. And the person taking the video, are they on the same side of the street as you are or a different side?
Objection, just say.
Overruled. You
Looks
may
to be
answer.
the same side as our street.
Okay. And you just saw the dancing grannies go through?
Correct.
Does that accurately depict what you observed prior to the car coming through the parade?
Yes.
Okay. I would ask the court to admit exhibit number 50 and ask that it be published for the jury.
Your objection's noted. Exhibit 50 is received. Permission to publish is granted.
So we're going to start at 0 and just go through the 11 seconds. And then I'll ask you questions about the video if you may send it. Sir, is that the red SUV that you previously described as striking your daughter?
It is.
And that white vehicle that you saw in that frame, was that the vehicle that you saw that was impeding your ability to see it initially, or is that a different vehicle?
Objection, hearsay.
Overruled. You may answer.
I believe that was a different vehicle.
Okay. And was that the path of travel that you observed that vehicle take, which was on the north side, thank you, north side of the street?
It is.
And then after it passed that intersection, you indicated that it went towards the middle and into the grannies?
It felt like that. Definitely.
Thank you. Thank you.
All right. Any questions for this witness?
Yes. Just 1 second. Do you remember what time it was when you observed the vehicle?
I don't recall the specific time I saw a red SUV. No.
You stated earlier that you saw the vehicle clip the corner. Would that be fair to say?
I saw it clip the corner of where the children were standing, correct?
And what do you mean by clip?
Come into contact with children that were in the front of that group of kids.
Is that how you would define clip?
That's my definition of clip, correct?
You stated also that it veered quickly away from, I'm guessing, that corner. What do you mean by veered quickly away?
The vehicle at one point was coming straight at us, and then the next moment it was heading 45 degrees back on the original route, so it quickly turned to get back onto the street. Otherwise it would have come onto the corner, onto that intersection at Clinton Street.
So it's fair to say if the vehicle did not quickly veer, as you say, it would have ran right into the people on the corner.
That's a fair statement, yes.
Is it also a fair statement to assume that the vehicle veered quickly away from that because it didn't want to strike the people on that corner?
Objection.
Grounds.
Speculation.
Grounds.
Sustained. Calls for speculation on the part of this witness. You do not have to answer.
In your opinion, why would the vehicle have quickly veered?
Objection again.
Grounds.
Speculation.
Grounds.
Sustained. Calls for speculation.
If you were driving the vehicle and were able at any time to see people directly in your path, would you veer away?
Objection. Relevance for this
Grounds.
trial.
Sustained.
And I the grounds for the sustain?
It's not relevant for this witness to answer that question. Calls for a hypothetical that he has not been qualified to answer. So it's also on foundation grounds.
Did you get a look at the driver of the vehicle?
I recall looking into the window, but my memory doesn't put a face to that or an image to that, so no.
Did you get the license plate number of the vehicle?
No.
You see any tents on the vehicle that you recall?
No, I was not paying attention to the vehicle after it came down barreling up the children. My eyes, tunnel vision to the kids.
So it'd be fair to say that with you focusing on the kids, it would be difficult to describe the vehicle at that point.
Outside of it obviously being a red SUV in my mind as I saw it come down, I couldn't recall any other details about the vehicle.
So it'd be fair to say the only thing you can recall about the vehicle was the color of it.
That it was a red SUV, a larger vehicle.
So the color of it.
Correct.
You stated that you initially waited before you seek medical attention. Any reason why you would wait?
I walked through the variables earlier. The hospital was on lockdown. I'm familiar with hospital operations enough to know that the acuity for my daughter didn't warrant me taking resources from other victims. My wife's a provider, an urgent care nurse practitioner. I felt she would be in a better position 15, 20 minutes later to assess and handle that from there.
You stated you did the father thing, as you put it, and downplayed the significance of the injury. Any reason why you would downplay it?
I think my initial reaction was a little confusion of what was going on and not seeing any bones sticking out or any blood. I immediately went into this sort of you're okay, meaning compared to everything else I'm seeing around us, you're in an okay position right now to get home. So I don't know if it was downplaying the injury per se, but it was more of just a triaging in my own mind of going, it's not that, it's okay.
It would be fair to say that the language you used was you downplayed the injury. Would that be fair to say?
Yeah, that's correct.
After the vehicle passed you, did you observe anyone being struck?
No.
Before the vehicle approached, did you observe anyone being struck?
Yes.
You also stated that at one point, after you were observing the path of travel of the vehicle, that it felt like it was straightening up into the middle of the parade route. Would that be fair to say?
Yes.
What do you mean by it felt that way?
Maybe in an incorrect term on my part. My memory, my recollection of the memory was that when it veered off, it went on and continued down the middle of Main Street.
So would it be fair to say that you really don't recall?
And I certainly recall the vehicle heading back down Main Street, down the middle of Main Street.
I'm referring to you saying that it, what it felt like as opposed to what you recall it doing.
I used the incorrect term there. When I said felt, it was more of the word choice of recall I should have used.
And you stated that you would estimate the speed of the vehicle to be about 25 miles an hour.
I said 25 to 30 miles per hour.
So somewhere in between that.
Correct.
And you also stated that it was the vehicle was about 30 feet away from you.
When I first initially saw the video, the vehicle was 30 feet away. It was just on the other side of the vehicle, the large suburban vehicle.
So how could you come to the determination of the speed?
Because it was barreling right at us. So as it came around the vehicle, started coming towards us, it felt like 25 to 30 miles per hour. And then as it veered off, no brake lights, just veered off and continued right down Main Street at that rate of speed.
So it felt like that was the speed. Is the term you just used again, felt. It felt like it was going that speed.
So I'm using the term felt, and I am defining that as sort of a mental recollection or a gut feel. I'm not trained in assessing speed, so my gut feel, what I felt at that time, driving that street numerous times, is that it was going 25 to 30 miles per hour.
So would it be fair to say, based on what you just said, that you're not trained in speed analyzation, that would it be fair? Would it be fair to say that you don't know exactly the speed of the vehicle?
Objection.
Grounds.
Answered.
That's based on what he
Hold
said.
on, you asked multiple questions, so I'm going off of the very last question that you asked. And that is, would it be fair to say that you don't know the speed of the vehicle? To that question, the objection's overruled and the witness may answer.
Yes, without looking at a speedometer, I would have no way of knowing exactly how fast that vehicle was going.
Did you notice any damage to the vehicle at that point that it passed you?
I don't recall honing in on that level of detail on the vehicle, so I don't recall.
Do you recall if you may have seen anyone else present in the vehicle?
I don't recall.
Did you ever make any statements to law enforcement after the incident at any time?
My wife and I both shared information on behalf of the crash report and our findings, or our initial statement.
You recall if that was the same night of the incident or in the following days after?
That was the following days.
Do you recall if it was a few days after or maybe a week or two?
I don't recall specifically. I believe probably within a week or so.
Any idea why it took so long for you to give a report? You and your wife, rather, to give a report?
Yeah, just dealing with my daughter and getting her situated, and just the magnitude of the incident, I think it took them a little bit longer. I think we were in contact pretty quickly, but it just took a while for them to get the resources back to us to collect everything.
Did you initially initiate the contact with attempting to file a report?
I can't recall specifically. It's been close to a year, but I believe we did reach out to the DA's office at some point in the following days.
Did you do any follow-up after that initial contact to see if maybe your report had been filed or anything like that?
At that point, the DA's office stayed in contact with us to let us know that everything they needed had been captured.
Do you recall who you talked to from the DA's office?
I don't recall.
Do you recall being told that you may be called to testify in this matter?
I do.
Were you seeking to testify in this matter?
I know I was subpoenaed directly from the state, the DA's office.
So you didn't have any intention to testify in this matter before being subpoenaed?
I knew it was a possibility. I never reached out to request to testify. I let them do their job, and they reached out to me to let me know that I would get subpoenaed.
Have you read or seen any complaint in this matter?
Objection day.
Grounds?
Sustained.
Have you or your wife filed any claims in this matter?
Which claim? Define claims.
Referring to being an injured party or anything of that nature?
We submitted a claim with the DA's office, I believe, for potential medical reimbursement
So that would be in regards to the medical bills.
for my daughter, correct?
So would it be fair to say that you have a financial interest in this matter?
Objection.
Grounds?
Relevance.
Grounds?
Sustained.
Would you consider yourself to be an injured party in this matter?
Me personally, no. Not physically.
So you weren't injured in any way in this?
Not physically injured, no.
Are you aware of the plaintiff in this matter?
Objection. Relevance.
Grounds?
Sustained.
Ever had any contact with the plaintiff in this matter?
Objection.
Grounds?
Vague. Sustained.
Ever had any phone conversations or personal interactions with the plaintiff in this matter?
Objection.
Grounds?
Again, with regard to the nature of the question, it's vague.
Sustained.
I don't believe that's vague, Your Honor. I asked specifically if there were any phone conversations or personal interactions. I don't think that's vague. I think that's pretty clear.
Sustained.
And I also believe the jury deserves to know if there is a plaintiff in this matter.
Your objection's noted. It's to that particular statement, or your statement is noted. To the objection from the state, it is sustained. Next question, please.
Are you aware if there even is a plaintiff in this matter?
Objection.
Grounds?
Sustained.
May I have the grounds for the sustain, Your Honor?
Relevance.
I would object and say that it's very relevant, again, citing
Your
that.
objection is noted. Next question, please.
Were you ever contacted by anyone who identified as the plaintiff in this matter?
Objection.
Grounds.
Sustained, it's still vague.
That's pretty clear, Your Honor. The jury deserves to know this information.
Mr. Brooks, the objection has been sustained. Next question, please.
No further questions.
Thank you. Any redirect?
Briefly. Sir, at cross-examination, you had testified that you did not see any brake lights. Is that correct?
That's correct.
Objection.
Ground.
Relevancy.
Overruled.
Sorry, correct, yes.
Okay. You testified further on cross-examination that you observed the red SUV strike an individual to your left. Is that correct?
Objection. He also stated that he was focused on his children and not focused on.
That's an argumentative statement. What's the legal basis for your objection, Mr. Brooks?
That is hearsay.
Overruled.
I did not see the individual to my left get hit. I just saw her on the ground, or the victim on the ground.
After you saw her on the ground, did the red SUV stop?
Objection. Hearsay.
Overruled. You may answer.
I did not see the red SUV from that duration of the parade. I didn't see the red SUV until the vehicle had already passed that position and came around the other large SUV. So I can't speak to what happened back there.
Was there anything that you could see in the roadway that would have prevented that red SUV from stopping before it started veering towards your group?
Objection. Hearsay. Stated he didn't see.
The
Couldn't see
objection
above
to
that.
hearsay is noted. It's overruled. You may answer.
Can you ask the question again, please?
Certainly. Did you see anything in front of you that would have prevented the red SUV from stopping as it passed that car that obstructed your view initially?
Objection. Irrelevancy.
Overruled. You may answer.
Nothing that I saw would have stopped him. That wouldn't have allowed him to stop.
And after he impacted your group that was watching the parade and it continued on towards the dancing grannies, was there anything that you could see that would have stopped the red SUV?
Objection. Who is the he you're referring to?
I don't understand the objection. Were you done asking your question?
I was.
Overruled. You may
Objection.
answer.
I don't consent to being called he. We don't even know the he that's being referred to.
Overruled.
The witness didn't identify a he.
Overruled.
I don't recall seeing anything in the road that would have stopped him from stopping, prevented him from stopping.
Thank you. Nothing further.
All right, thank you. You may step down. This will be an excellent point to take our mid-morning break. We'll be in recess for about 15 minutes. All rise for the jury, please. All right, thank you, everyone. We are in recess. We'll be back in about 15 minutes.
down. It's okay. Stop it. Just stop. I'm like, oh, that's pretty obvious. I'm gonna use your restroom.
All right, we are back on the record. Appearances are as they were before. Madam Clerk, have the jury come out, and the state should be ready to call its next witness.
Still appearing by a third party for my client in this matter. As a living human being. Also would like for the record to address subject matter jurisdiction again, Your Honor, if you would like to answer that now.
No, I would not. And will not.
Is that a judiciary determination?
The record stands. I've previously addressed that issue.
So you will not be answering that.
All right, the record should reflect the jury is coming in.
Is that a tacit agreement again, Your Honor?
I'm not answering that.
So is that a yes or no? I'll take that as a yes for the record, Your Honor.
That's not either, sir. I'm not
You
answering
didn't
that.
reply. Remember, non-response is consent.
All right, thank you, everyone. Please be seated. State may call its next witness.
The state would call Heather Rashadi.
All right, good morning. Ms. Rashadi, if you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and my clerk, Teresa, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please be seated. First thing I will ask you to do is to state your first and last names for the record and spell each.
Heather Rashadi, Heather Riccioti.
Thank you. Go ahead, your witness.
Thank you. Ms. Rashadi, I want to direct your attention to November 21st of last year. Were you at the Christmas parade held on Main Street in the city of Waukesha?
I was.
Who were you there with?
I was there with my 3 children.
How old are they?
At the time, they would have been 7, 5, and not quite 2.
Do you recall where you were seated or standing?
We were on the corner by the steaming cup.
Okay. I'm going to ask that Exhibit 51, which was previously admitted into evidence, be published to the jury.
Objection.
Permission granted.
Ma'am, do you see the area highlighted on the screen in front of you? Actually on the table right in front of you.
Oh,
Sorry.
yes.
Okay. And does that look familiar as the steaming cup?
Yes, we were on the paver portion of the corner there.
Okay. Can you circle or put an X in the area that you and your 3 kids are at, approximately?
Sure.
It's a
Touch screen, okay. So I would have been a little bit further back from my kids, maybe like over here. And my 2 older kids would have, they were in the street right about there.
Okay. And at some point, were you standing, I'm sorry?
I was standing and my youngest was in a stroller with me.
Okay. And the other 2 kids, were they in the street?
Yep, they were with the other kids that were just waiting for candy from the floats.
Were their kids on like your right side as you were watching the parade?
They were kind of just in front of me, a little to the side though, yeah.
Okay, thank you. What, was that the approximate area that your kids were standing?
Even out probably a little bit further than where I circled.
Did anyone raise a concern about where they were standing at some point during the parade?
There was concern about it. A police officer had come by and actually moved all the kids back a little bit. And there was another mom there, and her daughter was near my kids. And she had actually said to me, gosh, they're out a little bit far. And I said, everything's going so slow, they're not going to get hit. They'll be fine.
So At some point during the parade, was your attention diverted from what was the floats and the participants and the spectators to something else? Was your attention drawn away?
Yeah, there was one point when there was a break in the actual parade, and an SUV came down the road, and it was coming faster than any parade float should have been coming, so it was confusing, and I didn't know what was happening at the time, but it did veer into the crowd, just right in front of me where my son got hit.
Okay. So first of all, can you draw an arrow on the direction that the vehicle was going?
Sure. It was coming from this way.
Okay. And what direction, if you can kind of follow that line, what direction was it going as you said it veered towards you?
It wasn't going straight. It was just kind of like, and then it just kind of went in this way and ended up right about there.
Okay. Were any of your kids, one was in a stroller that was by you, up on the ledge, I think, or the...
Yeah, further back.
Were either of your other two kids struck by the SUV?
My middle son, Owen, was struck by the SUV when it came through.
And Owen is 7?
He was 5 at the time. He's 6 now.
Oh, I'm sorry. That's exactly
He's
what
the
I
middle
wrote down.
one.
I was just testing you to make sure that you knew the ages.
It's hard to
of your
keep them
kids.
straight, but I
Yeah.
sometimes do.
Thank you. Did you see the path of travel after the SUV came towards you and hit Owen?
I didn't, because I gathered up my kids as fast as I could, and we had parked in the public lot down here, and so I just gathered them up as fast as I could, and we just ran to the car and to get out of there. There was a lot of chaos and screaming and crying. And
Did you? What injuries did Owen receive?
he ended up needing 6 stitches. He had a gash on his eye, above his eye, like in his eyebrow. So we needed 6 stitches because it was pretty deep. They couldn't just glue it or anything like that.
Now, you put your hand above your right eyebrow. Was it above his right eyebrow?
Yeah.
Okay. And where were the kids facing? If you recall, right before the SUV came and struck Owen.
They were waiting for the next float, so he was turned facing the way the floats were coming because there wasn't anything going on at the time. We were just waiting for the next thing, so they were just watching for the next float to come by.
Okay. So I'm assuming his body...
Yeah, he was turned.
Okay, thank you. Did you get medical attention right away?
I dropped my youngest and my oldest off at home, and then I quickly took Owen to Waukesha Memorial.
And that's where he was treated?
That's where he was treated.
Did you see, first of all, what color was the SUV?
It was a maroonish red.
Okay. Did you notice anything distinctive about it other than it was a maroonish red SUV?
No.
Did you see the vehicle prior to it striking Owen strike anyone?
I didn't.
Did you see the vehicle strike anyone after it struck Owen?
I didn't.
Nothing further. Oh, sorry. Nope. We'd ask that a screenshot be taken of State's Exhibit 51. I believe that would be 51A.
Objection.
And we'd ask that it be admitted into evidence.
Objection.
Overruled.
My objection was to clarification on whether she was done or not.
I believe it is 51A. It is also captured, and did you move that one, Ed, to evidence?
Thank you.
Sorry, did you move 51A?
I did.
All right, and 51A is also received.
And the state would have no other questions for this witness. Thank you.
All right, any questions, sir?
Yes. You stated a few minutes ago that at one point before the vehicle came through that you were having a conversation to the effect of things were going slow, they're not going to get hit.
I never said I was having a conversation.
Well, let me back up. Who were you talking to when you said everything's going slow, pretty slow, they're not going to get hit?
Another mom.
So would it be fair to say that's a conversation?
Yes.
And why did you make reference to getting hit at that point?
Because I didn't expect my kid to get hit at a parade.
So you had already made the determination that they were going to get hit at a parade at that point?
Objection.
Grounds.
Argumentative, sustained. You do not have to answer that question.
Why would getting hit be in your head at that point?
Objection.
Grounds.
Relevance.
Grounds.
Overruled. She may answer the question.
I wasn't concerned about my children being hit at a parade because typically at a parade floats are going very slow.
It still doesn't quite answer the question because the statement was things are going pretty slow, they won't get hit. What prompted the statement they won't get hit at that point?
Another mom was concerned about how much into the street the kids were waiting for candy.
So it'd be fair to say that the initial concern was from another parent
Correct.
and not yourself.
I wasn't worried about my kids getting hit at a parade as I shouldn't have been.
You stated also that you dropped your other kids off before seeking medical attention. Would that be fair to say?
I said that.
Any reason why you didn't seek medical attention immediately?
I did seek medical attention immediately.
You also just stated that you dropped your other kids off. And
My house is on the way to the hospital, so I dropped 2 of my children off so they wouldn't have to sit at the hospital.
So your intention at that point was to seek medical attention.
I sought medical attention.
Was
Yes.
that your intent?
That's what I did.
Was it your intent?
Objection. Argumentative.
Grounds.
Sustained. Asked and answered.
Do you recall about what time you arrived at the parade?
No,
You recall what time you left the parade?
no.
Were you at the parade with anyone other than your children at that time?
No.
Before you were able to see the vehicle that struck your son, or was it your son?
Yes.
Before you saw the vehicle, did you observe anyone else struck before that moment?
No.
After that moment?
No.
About how long did it take you to gather your children up before?
Not very long.
Do you recall how long you were treated at the hospital?
I don't know. We were there for a while waiting. The waiting room was full of people that were hurt.
Were you ever told at any point during your waiting process that you probably could have went to another medical facility?
Objection.
Grounds.
Sustained.
You recall giving a statement to law enforcement?
Yes.
Do you recall if it was the same night of the incident?
I gave a report the night of the incident at the hospital.
And did you follow up on that report at any time?
No, I didn't.
Any reason why?
Why would I follow up?
Well, it would be fair to say, would it not, that after making a report to law enforcement, you would want to follow up maybe to see what's going to be done about the report. Would that be fair to say?
I knew that the police were going to do their jobs, so I didn't have a reason to follow up. They contacted me when they needed to contact me.
So it'd be fair to say you just gave the report and then just left the rest up to law enforcement?
Sure.
And I'm assuming that law enforcement at some point got back in touch with you. Would that be fair to say?
Correct.
Do you recall about when that was?
Either the next day or the day after.
Do you recall if it was a detective or a regular officer?
I believe it was a detective.
Do you recall the name of the detective?
No.
Were you at any time given a card by the detective to be able to keep in contact?
I don't recall.
Do you recall if your interview was written down as a summary or if it was recorded?
I think he did both.
Did you file any claims related to this matter?
No.
Ever read or saw a complaint in this matter?
No.
Grounds.
Sustained. You may rephrase if you want. But sustained as to the form of the question.
Whom were you contacted by in regards to possibly testifying in this matter?
I don't know. Probably the DA's office. I don't know.
Were you subpoenaed?
I was subpoenaed to be here.
Do you recall who that subpoena was from?
I don't know.
So it'd be fair to say that you received a subpoena and never read who it was from. Would that be fair to say?
From the state of Wisconsin.
When you say the state of Wisconsin, who are you referring to?
Objection, relevance.
Grounds.
Sustained.
Grounds for the sustain.
Not relevant.
Will you consider yourself an injured party in this matter?
I was not physically injured myself.
Have you filed a claim in this matter in any way?
Yes, answered.
Sustained.
Would you consider yourself to be the plaintiff in this matter?
Objection, relevance.
Grounds.
Sustained.
Grounds for the sustain.
Not relevant. Also under 90611.
Are you aware of any plaintiff in this matter?
Objection.
Grounds.
Sustained on relevance grounds.
Ever had a conversation with the plaintiff at any time in this matter?
Objection, relevance.
Grounds.
Sustained as to the form of the question. You may rephrase it if you would like. Some more specificity.
Have you ever had any phone conversations or personal interactions with the plaintiff in this matter?
Objection, vague.
Grounds.
Sustained as to the form of a question. You may rephrase it if you so choose with more specificity so that it's not vague.
Are you aware of the identity of the plaintiff in this matter?
Objection.
Grounds.
Not relevant.
Grounds.
It's not relevant. Sustained.
Are you aware if there is a plaintiff in this matter?
Objection, relevance.
Grounds.
Sustained
Grounds for the sustain.
on relevance grounds. Also under 90611.
With all respect, Your Honor, the jury deserves to know this information. We're withholding important information from the jury. They deserve to know this.
The jury will disregard the statement made by Mr. Brooks as not being an accurate statement of the law. Next question.
So to the best of your knowledge, you're not aware of any plaintiff in this matter?
Objection.
Grounds.
Sustained. Mr. Brooks, please move on to another topic under 90611. You are hereby advised that if you do not move on to a new topic, I will close the cross-examination.
With all due respect, Your Honor, this is important information the jury deserves to know.
Mr. Brooks, ask a relevant question, please.
That holds a lot of relevance, Your Honor.
Mr. Brooks, one last opportunity to ask a question. Otherwise, the court will declare the cross-examination closed under 90611.
No further questions.
Any redirect?
No, Your Honor.
Thank you, ma'am. You may step down. Statement called. Next witness.
Daniel Knapp.
All right, Mr. Knapp, if you would please make your way to the witness stand, which is to my right, up one riser. When you get there, please remain standing, raise your right hand, and my clerk, Teresa, who's to my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. First thing I will ask that you do is to state your first and last names for the record and then spell each.
Daniel Knapp, D-A-N-I-E-L, Knapp, K-N-A-P-P.
Go ahead, your witness.
Thank you. Morning, sir.
Morning.
I gotta direct your attention to November 21st of 2021. Were you at the Waukesha Christmas parade on that date?
I was.
Who were you with?
I was with my family, my wife, and 3 children, as well as 3 other families. There was a group of 19 of us.
And by chance, were you with, I'm sorry, Your Yes, thank you. Matt Harris?
Yes.
And Matt have his...
Hold on, overruled. The question and answer will stand.
Sir, how old are you kids?
My kids at the time of the parade were 11, 7, and 3.
Where were you seated for the parade?
My family was in front of the Steaming Cup, so that would be on the northeast corner of Main and Clinton Street.
And I said seated, but I guess were you standing or where were you on that corner?
Yeah, so I was behind the group of, we had 12 children that were lined up across the street or on the side of the street waiting to receive candy. I was behind the children, so closer to the Steaming Cup.
Was that the same general location as the other parents?
That is correct, yes. My wife, Stephanie, was with my daughter, Kelsey, going in and out of the steaming cup, given it was a little chilly that day, and my daughter was a little cold, so she would go in and out of the steaming cup. So she was a little further to the west than I was, but we were all in the general direction.
Okay. And how old is Kelsey?
Kelsey, at the time of the incident, was 3. Today she's 4.
Okay. Now, at some point, did you hear anything unusual during the parade?
Yeah, so in watching the parade, with a lot of circumstance pomp, bands and noises, but then all of a sudden the noises changed to what I would describe as sounds of screaming, and at the time when that occurred, the direction kind of turned from facing the parade down to the east, looking down Main Street.
So as you're facing the parade, would east be to your left?
That is correct, to my left.
To your left. And when you said screaming, you said this is a parade. I'm assuming that there are kids and adults screaming and yelling. What was different about the screaming that you heard?
In my recollection, there is a difference between laughing and having a joyful time as compared to screaming out of fear, terror. It was just a noticeable difference.
And the screaming that you heard out of fear or terror, that was the screaming that you heard when you looked left?
That is correct.
Okay. What did you see?
So what I saw when I looked left was there was a SUV pulling a float that was down to our left side that had not got to the position that we were at, and all of a sudden a car, red SUV, pulled around that float and headed directly in our direction. You said a red SUV. Did you notice anything unusual about it as the car came at you? Other than obviously a car coming at us during a parade was something that was very unexpected. And as it got closer, as I mentioned, it was coming at maybe a northwest direction as it past the SUV, coming directly at our location. And in terms of anything else at that point, no.
I'm going to show and ask the court to publish Exhibit 51. It will show up in front of your screen.
Go ahead.
First of all, sir, is this, does this area look familiar to you?
It does.
And where's the steaming cup?
The steaming cup would be the building I'm circling right now.
Yep. Okay. And where were you seated or standing, approximately?
Yeah, so I was standing somewhere right about here.
Okay. And where were your kids?
So we had, like I mentioned before, a group of 12 that were lined up. Kelsey would have been the furthest to the west, and I would approximate that the 12th child furthest to the east would have been somewhere in this direction, or location, excuse me.
And do you know approximately that would have been the location she would have been on the curb, meaning Kelsey, or would she have been off the curb, if you recall?
It's my recollection that she would have been off the curb. There was a lot of excitement with the children, and there was a police officer that would often push the children back to ensure that they were staying out of the direction of the parade. And so it's my recollection that they would have been on the street at that time.
Okay. And still using Exhibit 51, when you state that this red SUV was coming at your group, can you, and I don't know if you can you show the direction of travel using this exhibit?
Overruled. You may answer.
Thank you. I would, the direction I would based on my recollection, was coming here, and again, right at our location, so coming here and then would have come back this direction into the middle of the street.
Okay. So let's kind of go through that. When you first saw the car, was it on, can you show by an arrow using exhibit 51? Can you show by arrow the, and I think you actually have, the direction that the parade was going? You did with the arrow that you previously pointed, is that?
Yeah, the direction of the parade was coming in this direction here.
And where specifically was the car coming from? Was it coming from, as you're looking at the car, was it coming from the left side of the road or the right side of the road?
Objection, leading the witness.
Overruled.
The car was coming from the south side of Main Street.
Which is,
it had,
you're on the north side?
I'm on the north side
Okay.
by Steam and Cup, so it had passed the SUV on the south side and then came into our purview at that point, coming on a northwest direction towards us.
So the red SUV passed another SUV?
That's correct. It had passed an SUV that had yet to come to our location. So I'm not exactly sure what unit that was in the parade, but as it passed that SUV, it came into my purview, and that's what I got sight of the vehicle.
So the SUV that the red SUV passed, the red SUV would have passed the other SUV on the driver's side?
That is correct.
Okay. If I could have a screen capture of this, I believe it would be 51B. And then,
It is captured, and we'll save it as 51B.
It also has,
Hold on. I'm sorry, was there an objection
Yes.
on the basis for the objection?
Relevancy.
It is relevant. 51B has been captured, and I believe you had a statement about it.
yes, I'd ask that be moved into evidence.
It is received, 51B.
The objection be noted for the record, Your Honor.
It already has been.
No.
Yes, it will be noted.
Sir, continuing to look at 51, you had stated that the
Look at those. I'm not certain if they're asking for, it would be my perception that they're confusing deposition transcript with trial transcript, in other words, the testimony. Because I don't think we talked about a deposition transcript for any witness. Was there any mention of it? And they might just be getting those terms confused.
During my cross-examination of Dr. Denny, there was a conversation about his deposition.
Okay, well, so this is my suggestion. I would like to send them back a note that says, jurors, with regard to your first inquiry about Dr. Denny, deposition transcript and/or video, please be more specific about what you were requesting so that we may accommodate you. Is there any objection to sending that back just so that I know and that you all know exactly what it is they want so we can figure out if it's possible?
Maybe they want his testimony.
Right, I don't know. And the reason I'm not sure if they're confused, but I'm confused, is because the other question says, please, may we receive transcripts of Dr. Connor testimony? But the handwriting is different, so whoever wrote the third note is not the same person that wrote the first note, so maybe they just wrote it wrong. That's why I would like to ask them to be more specific.
I think you could just ask her, you asked them for trial testimony of both witnesses.
But they mentioned a video, and there were video clips.
Well, it says both.
Well, it said and or. That's why I.
Oh, they might mean like a video of their
Correct,
testimony, like
because also my recollection is, and I've obviously had time to think about this longer than you all, but Dr. Connor testified via Zoom, if I'm not mistaken.
Yes, ma'am.
So they might be getting confused about who testified live and who testified via Zoom. They might think that Zoom, because it was on the screen, is a video. I don't know. That's why I think we need to ask them to be more specific with regard to question number 1. Is there any objection? No. Okay, I'm going to print this out, make it court exhibit, what are we on?
I'm sorry, reason is 14? 14, thank you.
Okay, in the meantime, I think we can discuss the second question, which says, DSM-5TR, can we get a copy? Next line, CDC guidelines, and then in parentheses, current. My recollection is that the DSM is not in evidence. Does everyone agree to that?
Yes.
And the CDC current guidelines are not in evidence.
Correct.
Except in the testimony. It's within the testimony.
So with regard to the request for a copy of these two books or guidelines, I'm inclined to tell them that these items are not in evidence.
You have to.
I agree. Okay. Or I'm thinking maybe I should say all of the items in evidence for your consideration have been provided to you. Because I don't want them to think it's a trick answer. They're not in evidence, so they have to ask in another way. I'm gonna make it clear that we can't give them those items and that they have everything that we can give them.
Unless they want readbacks of testimony.
Thank you. Okay, so the answer reads, jurors, with regard to your request for a copy of the DSM-5 TR and the current CDC guidelines, neither of these items are in evidence. All of the evidence has been provided to you. And then it's signed and dated. Is there any objection to me answering the question in this particular format that I just read?
No, Your Honor.
Defense?
No, Your Honor.
Okay, this is going to be marked as Court Exhibit 15. The jurors are asking. Okay, the sheriff's office, since the jurors have asked for a folder to put their questions in.
No objection.
No objection.
Okay. Thank you. Now, moving on to the third question about the transcripts of Dr. Connor testimony. So I know that normally what would happen is the jurors would be brought back in and we would have a read back. However, in this case, we do have the benefit of having real-time reporting, and according to our lovely court reporter, these transcripts have been prepared. Is there any reason why we could not obviously review the transcripts to make sure the sidebars and things that are not for their consideration are taken out, and then simply give them the certified transcript as opposed to...
I think it has to be read, Your Honor.
You do?
I do too. I don't think you can send back a transcript.
Even, okay. What's the difference though?
I just recall a case, but we'd have to do research if the court wanted us to, but I believe I recall a case that just you don't know who's reading it.
You don't know who's reading it, Your Honor, and you don't know what emphasis, if they're all reading it or they're only reading parts of it, and if it's being passed around or not. So it would avoid any potential error. I know it takes more time, but we've already invested a lot of time.
No, I understand. I mean, we haven't had this real time for very long. That's why I'm wondering if this has actually ever been considered. Because if you think about it, there probably are just parts of the testimony that they want to hear.
Do you want to
I
ask
think
them?
you have to read the whole thing. The readback is a readback.
Sure, on a readback, yes. But what I'm saying is, even if they did want to emphasize certain parts of the testimony, that would be okay because it's per their request.
Yeah, but you don't know because, people ask questions, follow up later. I mean,
Okay, let me just,
As I was giving them that previous one, they came with it.
Okay, so I just got the clarification. They are asking for the transcript of the testimony given by Dr. Denny.
okay, so it's a readback.
Okay, so they asked for Dr. Denny's first and Dr. Connor's second. So I suppose we do a readback of Dr. Denny's testimony and then Dr. Connor's testimony,
Well,
which is going to take 4 days or 5.
it reads faster than it's presented, but Dr. Connor came first in terms of the testimony. It would make more sense for Dr. Connor and then Dr. Denny, because Dr. Denny's rebutting Dr. Connor. So in order to have the context as it was presented to them, it was Dr. Connor and Dr. Denny.
I was just gonna go in order, but I guess that makes sense because there was a lot of questions about Dr. Connor's testimony to Dr. Denny, if I'm not mistaken. So is there any objection to doing Dr. Connor's testimony as far as a readback and then Dr. Denny's testimony, even though that's not the order that they asked for it?
Judge, it's our position that the jurors should have the testimony read back in the order in which they requested it.
We would object to that procedure because it's just what you said, Your Honor, that Dr. Denny was a rebuttal witness. It's not going to make any sense unless what he's rebutting is placed on first.
And the jury asked for the testimony in a specific order, and we can't ask them why, but that is in fact the way that they requested it.
Okay, we have to get another court recorder. And it's going to take some time. So, will you all just give me a moment to talk to Trish when she's not typing?
Sure.
Ms. Bailey, please.
Transcripts, bring them back in here and allow them to review the transcripts that they want to review, and then we're here to make sure that we, that there's not one person that is saying something to another juror. This would be the exact same thing we would do with a readback, and it might be a little bit more efficient than having to get another court reporter, wait for a court reporter. If she's essentially going to be reading the transcript, if we can give them a hard copy of the transcripts. And just have them review it in here.
Sorry.
No, go ahead.
No, I object to that procedure. I think it should be a readback. So they're all hearing it, assuming they all read, you don't know if they all read at the same speed
or read it all.
And
Well, I think we do know that, right?
I think it should be a readback, just like any other case. And if there's a question about who should go first, maybe the court can send is there a special order, or do you want it the way it was done in court? Because I think Dr. Denny's testimony is not going to make as much sense because he's a rebuttal witness. He wasn't. That's my position.
I don't see the harm in having them clarify whether they want to hear the testimony in the order that it was received or the order in which they asked for it.
That's fine.
And I would just object to that clarification because their questions were, I didn't see them. Are they numbered?
They didn't number them, but they buzzed like 3 in a row.
So we don't know the order of the questions? Is that what you
Do we have the order? Did they give you more? They gave you 1, and then buzz, and then buzz, right? They did 3 buzzes. They were within, before even you all got here.
And the first buzz was for Dr.
The first buzz was the Dr. Denny. Then was the CDC guideline request, and then Dr. Connor.
Well, if you want to be technical, the first was for Dr. Denny's deposition, and the 4th request was for Dr. Denny's trial testimony.
I don't.
I'm not so concerned with that, Judge, because they may not understand the difference between the two, but clearly, they were requesting certain testimony in any form, in a particular order. And that's how I think it should be presented to them, because there was obviously contemplation of who they wanted to hear from and the order in which they wanted to hear it.
And I disagree with that. They said, well, Lieutenant, well, maybe we ought to hear Connors too. It's not, they're not asking for an order, they're asking for a readback for both. And it's my position, as I said before, that Dr. Denny is a rebuttal witness to Dr. Connor, and obviously, because of that, it makes more sense for Denny to go second.
Does Denny have one N or two?
Two,
Thank you.
and two E's.
D-E-N-N-N-E-Y.
Two.
D-E-N-N-E-Y.
Oh. Okay, thank you. Okay, this is the response that I'm going to send back. Jurors, we are preparing the testimony to be read back to you. This will take some time, so please continue with your deliberations while you wait. In the meantime, please clarify the following. Do you want the testimony to be read back to you in the order that it was presented during trial? Dr. Connor's testimony first, followed by Dr. Denny's testimony, or do you want the testimony to be read back in the order that you requested it? Dr. Denny first, then Dr. Connor. Is there any addition? I know you're objecting to this in general. Is there any additional objection that you would like to make?
No, ma'am.
Okay. And this will be marked Court Exhibit 16. So if we can give Ms. Bailey a break, she has a court reporter that she believes will be available to be coming over within maybe 30 minutes.
Yeah, I'll be able to get some.
She needs about 30 minutes to prepare to begin the read back. So while we do that, we can be in recess for 30 minutes. And I believe the jurors, when they had the first question, they just got their lunches, right? Have they eaten? But how long have they had lunch? Oh, they've had it a while. I was thinking that they hadn't had time to eat, but I forget that they're still working while we're in here. So it's 1 o'clock now. We'll be in recess until 1:30 so that we can prepare for what we need to prepare.
have a case, if you want to just read it while we're waiting.
Sure.
And it's the Avila case. I think the state.
But we don't have the court reporter's doing something and Ms. Cruz isn't here, so let's just wait a few
Oh, I
minutes.
was just
Otherwise,
going
we're
to
gonna
redo it. That's fine.
You're gonna do what?
I would just put this on the record when everybody got here. I just wanted you to have this. It's fine.
Okay, here. So this is gonna be.
Okay, the lawyers are present. The defendant is present. Court is back in session. We are just waiting for a nice court reporter who's coming from home. She's parking. She should be here any second. But in the meantime, I advised both sides that I was going to be sending back the following clarification. We are preparing the testimony to be read back to you. This will take some time, so please continue with your deliberations while you wait. In the meantime, please clarify the following. Do you want the testimony to be read back to you in the order that it was presented during trial? Dr. Connor's testimony first, followed by Dr. Denny's testimony. Or do you want the testimony to be read back in the order that you requested it? Dr. Denny first, then Dr. Connor. We received a response that states as follows, and you all can feel free to come look at it. It says, number 1, Dr. Connor, then there's a line, we would like to hear cross-examination. Number 2, Dr. Denny, then there's a line, all of it, and it's signed by the foreperson. So, I believe the jurors have clarified they want first the cross-examination of Dr. Connor, and second, all of the testimony of Dr. Denny, which is what Ms. Bailey has prepared to read back. And this is marked Court Exhibit 16, composite exhibit, which has my question and then their answer. Okay. Thank you for coming. Put something on the record. Actually, hold on just 1 second. Just give me 1 second. Sorry. Go ahead.
Sure. I think the issue may have clarified it by the jury's response, but I was just going to direct the court to 3.410, which kind of lays out what we do when there's a readback. And then there's also another case. Oh, just a moment. And then there's the Avila case, which is at 781 Southern 2nd, 413, which says that under the rule of criminal procedure 3.410, the court has wide latitude in the area of reading testimony to the jurors. In this respect, the trial court may provide a limited or partial readback of testimony specifically requested by the jury, as long as the testimony is not misleading. So I wanted to put that case on the record. And then, Judge, we believe that if the jury only has the cross-examination of Dr. Connor, that they would be misled. So we're asking that they also be read the direct examination of Dr. Connor, so they're able to put things into context as to the questions that Mr. Secor asked them. And in our opinion, a failure to do that would mislead the jury. So we believe that pursuant to the Avila case, that the entire testimony of Dr. Connor should be read. Please.
Judge, they have asked for a specific portion to be read back, and that is cross-examination. If the question was, please read us back Dr. Connor's testimony, I know this is just an example, illustrative. Give us everything he said about DNA, then we have to search the transcript for every time there was DNA evidence, but that's not what they're asking for. They're asking for, they obviously have a question about something that occurred in their minds about in cross-examination. They can always ask for more, but we're not trying to look for something for them. This is what they want to. This is what they're asking for. How is that misleading?
So, Judge, I understand exactly what they're asking for. I'm not in dispute with the state about that. But the case law is clear that the portion that the jury requests, if the defense believes that it is misleading to only give them part of the testimony, then the court should take that into consideration and allow the jury to have the entire testimony. As a court is aware, a direct examination, the majority of the evidence comes from the witness, and in a cross-examination, it comes from the lawyer. So we are asking that the entire testimony of Dr. Connor be read to this jury so that they are not misled about the testimony by only listening to the cross-examination. And I don't have any other further argument for the court.
Okay, I think the request was unequivocal, and I'm going to have Ms. Bailey read exactly what they asked for, and in the order that they asked for it, because I did ask them to please put their preferred order, and that is what they indicated. They want Dr. Connor's cross-examination, and then they want Dr. Denny, how did they phrase it? All of it. We have the court reporter present. Are we ready to bring in the jurors?
Yes, Your Honor.
Judge, this is gonna take some time. Are we gonna like take a break at a certain time, and are we gonna go straight through?
I have no idea how long it's going to take, but I generally try to go as long as possible until one of them asks for a restroom break, which is what we've been doing. They usually go for maybe an hour and 20 minutes.
Okay.
That's sort of the rule of thumb that I've been keeping track of for the trial. If we go more than an hour and a half, we'll take a break.
Okay, thank you.
Sure. And of course, if anyone has an issue before then, just pass a note.
Thank you.
Everybody passes notes.
Judge, I'm going to stop the real time right
Okay.
now. So the real time's getting stopped right now. Rashadi doesn't real time, so just to let everybody know.
Thank you.
Okay.
Okay, the jurors are present. Everyone else may be seated. Ladies and gentlemen, we are going to begin the readback of the specific testimony that you have requested, starting with Dr. Connor's cross-examination.
Question. Good morning or good afternoon, Dr. Connor. How are you? Answer. I'm doing well. How are you? Question. So let me start off. Are you board certified in neuropsychology? Answer. No, I am not. Question. How do you become board certified in neuropsychology? Answer. It's a voluntary process, not required in order to practice as a neuropsychologist, but it requires a period of study to take a written exam, then to provide various work samples that are reviewed and then eventually participate in an oral examination. Question, and you have not done that? Answer, that's correct. Question, are you board certified in forensic psychology? Answer, no, I'm not. Question, Do you have any formal training in forensic psychology? Answer, no. Question, are you board certified in any discipline? Answer, no. Question, do you recognize the American Academy of Clinical Neuropsychology? Answer, yes, I do. Question, okay. And do you recognize that as an authoritative source? Answer, it's one of the several neuropsychological societies in the United States. It's a very good one. Question, okay. And do you have the American Academy of Clinical Psychology listed on your CV? Answer, no. I have the American Academy of Clinical Neuropsychology. Question, I'm sorry, neuropsychology. Answer, that's okay. Question, yes. Answer, yes. Question, I thought that's what I was speaking about. Answer, okay. Question, okay. And you're a member? Answer, I am. Question, okay. Are you a full member or an affiliate? Answer, I'm an affiliate member. Question, isn't it against the bylaws to put in writing or orally that you are a member of the American Academy of Clinical Neuropsychology? Answer, that I am not aware of that. Question, okay. Well, if you get a chance, I suggest you check. I think it says that you have to say you're a member of the American Academy of Clinical Neuropsychology, or to print it, and I may be wrong, but it indicates that you can't do that unless you're a full member. Question, okay. And there was an objection. Question, okay. Are you licensed to practice psychology in the state of Florida? Answer, I am not. Question, how many criminal cases have you been involved in where Dr. Richard Adler has been involved? There was an objection. Answer, I do not know the exact number. Dr. Connor, you can answer. Do you want me to repeat the question? Answer, please do. Question, sure. How many criminal cases have you been involved in when Dr. Richard Adler was also involved in the same case? Answer, I do not know the exact answer to that. Question, okay. Answer, it's been a number of cases. Question, okay. If I said approximately 150 cases, would you agree or disagree? Answer, if you're including cases where I was only consulting, I was not doing an evaluation, then that's possible, yes. Question, and did you recommend Dr. Adler in this case? Answer, I do not recall if I had recommended Dr. Adler or if the team had already approached them. Question, and you indicated to Mr. Secor that you have been hired by the state in criminal cases? Answer, yes. Question, and you said for evaluating victims. How many victims have you evaluated for the government in your career? Answer, I'm sorry. Question, go ahead. You are going to answer. I don't want to interrupt you. Answer, I testified in one of those cases. I have had a couple of cases. Question, okay, so once. Okay. So how many cases, let me put it this way. What percentage of your income is derived from you being hired by defense attorneys in criminal cases? Answer, I don't know the specific percentage of my income. I know the percentage of my work that is criminal versus clinical. Question, so you have no idea what percentage of your income is derived by being hired by criminal defense attorneys in criminal cases? Answer, I don't track that number in my software. Question, and you have no idea? Answer, Answer, I do make more from criminal cases for sure. Question, right. Answer, and about 60% of my work is clinical. Question, so you have no idea how you would answer my question, how much of your income is derived by being hired by criminal defense attorneys in criminal cases? Answer, I derive more income from criminal cases than I do from clinical cases, yes. I don't know the exact number. Question, and you don't know what the money number is? Is that what you're saying? Answer, no. Question, okay, when were you hired in this case? Answer, I'm sorry. Question, when were you hired in this case? Answer, I was contacted in December of 2020 and the contract was finalized in March of 2021. Question, okay, when? Answer, March. Question, of 2020? Answer, 2021. Question, 2021, okay. And then you met with the defendant on May 20th, 2021? Answer, correct. Question, okay. And you met with him for 5 hours? Answer, yes. Question, and where was that? Answer, that was at Broward County Jail. I don't know the specific name of it, sorry. Question, okay, that's fine. And it was all in one day? Answer, yes. Question, and you did some interviewing? Answer, that's correct. What percentage of the 5 hours did you do interviewing? Answer, that's usually about 1 hour. Question, okay. Did you videotape that 1 hour? Answer, no, I did not. Question, did you audio tape that 1 hour? Answer, I did not. Question, because that wouldn't be interfering with any of your testing, would it? Answer, no, but it is also not part of my practice to video or audio tape any of my evaluation. Question, okay. Did you know in the state of Florida that defense counsel has a right to be present during any testing or any interview of one of their clients? Answer, I was made aware of that. Question, okay. And are you aware when a state expert examines a defendant in a criminal case, not only does defense counsel have a right to be there, but it has to be videotaped? Did you know that, Dr. Connor? Answer, I don't recall that. It was a sidebar, so just give me 1 second to get back. It continues on the following day. Question, good morning, Dr. Connor. Answer, good morning. Question, how are you? I think we ended last afternoon, so I want to ask you this question. Are you aware, according to Florida law, the state was required to videotape their experts' evaluations? Answer, I had been made aware that the state was required to have observers. I don't recall exactly whether that also included recording. Question, okay. You know the state's evaluations were videotaped, right? Answer, I'm aware of that, yes. Question, so you didn't know that, according to Florida law, the state was required to have the examinations, evaluations by their experts videotaped, correct? Answer, I knew that I was informed that they would be observed, that they were required to be observed. Question, okay, but not videotaped? You don't know that? Answer, I don't remember. Question, you don't remember? Answer, I don't remember being told that. Question, okay. Of the 3.5 hours, you met with the defendant for 5 hours, I think you testified yesterday, correct? Answer, yes. Question, and all in one day, right? Answer, yes. Question, yes. And so 3.5 hours, if my math is correct, we're done with testing, correct? Answer, yes. Question, okay. The 5th and the 6th tests that you administered were the finger tapping and the grooved pegboard tests for both the left and the right hand, correct? Answer, I believe that's right. Question, do you need more time? Answer, no, that's about the correct placement in the order as I look at it. Question, okay, so explain to the jury the finger tapping test. Answer, the finger tapping test is essentially you have a device, like a clicker, that you get when somebody goes through turnstiles, and you click to count the number of people, except it's attached to a board, and they are required to tap with their pointer finger as quickly as possible, pressing all the way down, letting it come all the way back up for a period of several seconds, and we repeat that task multiple times. Question, okay, and how long does that test last, the finger tapping? Answer, in total? Question, yes. Answer, probably around 5 or so minutes. Question, okay, and you do that with the left hand and the right hand, correct? Answer, correct. Question, and the finger that you use, depending if you're left-handed or right-handed, is your trigger finger, correct? Answer, regardless of the hand that you use, it's the pointer finger that is used. Question, right. That's what I ask. Whether you're right-handed or left-handed, it's the trigger finger that you use in the finger tapping, correct? Answer, I'll call it the pointer finger, but yes. Question, are you offended by trigger finger? Isn't that what people call that finger? You know, the trigger? Answer, I've always called it the pointer finger. Question, okay. So the groove pegboard test, would you explain that? Answer, it's again, a motor coordination task where the individual is asked to take a series of pegs. They're shaped kind of like keys and insert them into a series of holes on a board that have the groove for the key portion of the peg that are at different angles. And they have to basically rotate in order to insert the peg into the holes. Question, okay, and how long does that take? Answer again, depending on the person, approximately 5 minutes. Question. So isn't the group pegboard test more sensitive than the finger tapping test? Answer, not necessarily. Question. That's your opinion? Answer, they measure motor coordination in different ways. Question. Okay. So would you just say that you think it's more sensitive or you don't think it's more sensitive? Answer, I don't think it's necessarily more sensitive. Question. Okay. But on the group pegboard, the defendant had an average score, correct? Answer, that's correct. Question. So what was his score on the pointer finger or the trigger finger on his left hand? Answer, it was a T-score of 13, which is in the severely impaired range. Question, okay. And they were the only test for the motor domain that you gave, correct? The finger tapping and the group pegboard? Answer, that's correct. Question, okay. So, and the finger tapping with the left finger, the trigger, or the pointer finger on his left hand, that is one of the subtests that you put on your graph below the 2 standard deviations, correct? Answer, yes. Question, okay. So the Ray complex figure, you did not administer that test to the defendant, did you? Answer, that's correct. Dr. Black did. Question, okay. And Dr. Black is a board-certified neurologist? Answer, he's a neuropsychologist. Question, I'm sorry, board-certified neuropsychologist? Answer, I don't know about his certification status. Question, okay. And do you know when Dr. Black did his testing? Answer, he did his testing on April 29th and 30th of 2021. Question, and that was before your test, right? Answer, yes. Question, and Dr. Black was hired by the defense, correct? Answer, yes. Question, okay. So you, in establishing your graph that you've showed to the jury, you used the Ray complex figure test for visual spatial, correct? Answer, yes. Question, and that is the only test that you had on your graph for visual spatial domain, correct? Answer, as I said in indirect, yes. It's one of the iconic tests that we use for visual spatial and is very much a relevant test for FASD evaluation. Question again, so it's clear. That is the only test that you had in the visual spatial domain, correct? Answer, that's noted on the graph. Question, so the answer is yes? Answer, yes. Question, okay. And you also use the Ray complex figure for memory domain too, right? Answer, there are other portions of that test that access memory, yes. Question, okay. And those two are on your graph too, correct? Answer, correct. Question, so you use the Ray complex figure for visual spatial and also memory, correct? Answer, yes. There are different portions of the test. One that is purely visual spatial construction, and two that are memory related. Question, okay. And so the other test I would like to talk to you about is the auditory consonant trigrams test, right? Answer, okay. Question, okay. And would you explain to the jury that test? Answer, as I said on direct, it is a working memory task where you're having to do 2 things at the same time. Remember some letters and do some math calculations. And you're doing those 2 tasks at the same time for different lengths of time. Sometimes very short of an intermediate length and then of a longer duration. And so they do this calculation task for a period of time, and then we ask them those letters again, and they have to repeat those letters back. Question, okay, how long did that test take? Answer, that test is usually 10 to 15 minutes in that range. Question, okay. And so correct me if I'm wrong. You say it to, like you did in this case, the defendant, you gave him 3 letters. Answer, yes. Question, okay. And what do you tell him? I'm going to give you 3 letters. Answer, and you need to count backwards. When I knock, you tell me those letters. Question, okay. And so the first test was 9 seconds. Answer, they're interspersed. The first time period is a 9-second, well, there are 9-second time periods, 18-second time periods, and 36-second time periods. They're interspersed. It's not that we give only the 9s, then the 18s, and then the 36s. Question, okay, I stand corrected. But that's what you do. He has to remember the 3 consonants, the 3 letters, correct? Answer, correct. Question, and so there's 9 seconds, there's 18 seconds, and 30 seconds. And 36 seconds, correct? Answer, correct. Question, okay. So he did better on the 18 seconds than he did on the 9-second, correct? Answer, slightly. Question, okay. And he did better on the 36 seconds than he did on the 18 seconds, correct? Answer, again, he did slightly better. Question, okay. And so on the graph, below 2 standard deviations, you used the 9 seconds and the 18 second subtests that were below the 2 standard deviations, correct? Answer, the 9 second and the 18 second were below the 2 standard deviation. Question, right. Answer, cut point. And the 36 second was below 1.5 standard deviations. Question, okay, that's fine. I mean, you showed the jury the graph, it's there. But the 9 second and the 18 second you put them on the graph below the 2 standard deviations, correct? Answer, that was where his score placed him. Question, right. And that's where you put it on the graph, correct? Answer, yes. Question, okay. So on page, I guess it's 32 of your PowerPoint, Dr. Connor, you made a comparison, and maybe I can share this with you. So we can put it up on the screen for everybody to see. Aaron, I think it's 32. Aaron, it's 32, I think it's on the PowerPoint. Question, doctor. Question, okay. Doctor, can you see that okay? Answer, yeah. That was not in the PowerPoint that I presented yesterday. Oh, I take that back. I lied, sorry. It's not slide 32, but okay. Question, which slide? Answer, I see it. Question, which slide do you have? Answer, from the PowerPoint from yesterday, it was slide 27. Question, all right, then I'm sorry. Question, but whatever, you recognize this, right? Answer, yes. Question, and you talked about it yesterday, correct? Answer, yes. And you did this comparison, right? This is your graph, you did this, right? Answer, correct. Question, so if you look at the ways verbal under intellectual functioning, answer, yes. Question, the defendant scored a 93, correct? Answer, correct. And then on the nonverbal, on the RIAS, did I pronounce that right? RIAS? Answer, the nonverbal on the RIAS? Question, RIAS, yes. I'm sorry, the RIAS. Answer, yes. Question, was 60, correct? Answer, no. The verbal on the RIAS was 60. Question, excuse me. The verbal on the RIAS was 60, correct? Answer, yes. Question, so he did 93 on the ways, and on the RIAS he did 60? Answer, correct. Question, and if you go down one, the nonverbal on the ways was an 82, correct? Answer, yes. Question, okay. And the nonverbal on the RIAS was a 101, correct? Answer, yes. Question, with an IQ test, you can't fake good, can you? Answer, it's hard to fake good on testing. It's very test. Question, how about an IQ test? If I wanted to be an astronaut and I need a 140 IQ, how could I fake it? Answer, if you study it, you can, but otherwise, no, it would be very difficult to. Question, so you think you can fake IQ good? Answer, if you study the answers, I guess you can. Question, okay, moving on. You talked about yesterday about the DSM-5-TR, right? Answer, yes. So the DSM-5-TR has not established or accepted any criteria for the NDPAE, correct? Answer, not correct. There were general criteria that were discussed in DSM-5 which carried over into DSM-5-TR. Question, are you talking about the criteria in the back of the book under? Answer, no. Question, what page are you talking about where it's accepted criteria? On page 99 of the DSM-5-TR, I think it was 86 in the DSM-5, it has general criteria. It doesn't get into specifics. Question, okay, so then I stand corrected. The DSM-5-TR has not established or accepted any specific criteria for NDPAE, correct? Answer, as they hadn't had it in the DSM-5, they had general criteria in the diagnosis section. Question, okay, answer, in the front section of the book. Question, okay, whether it's DSM-5 or the DSM-5-TR, the DSM has not established or accepted any specific criteria for NDPAE. Isn't that correct? Answer, it has not established them. Question, so as pointed out, and I think you even mentioned it yesterday, NDPAE is listed in the back of the book under conditions for further study, correct? Answer, neurobehavioral disorder associated with prenatal alcohol exposure unfortunately using the same acronym, is cited in the back of the book under Conditions for Further Study. Yes. Question, okay. And on page 903 of the DSM-5 TR, it says, and you correct me if I'm wrong, the task force ultimately determined that there was insufficient evidence to warrant inclusion of these proposals as official mental disorders in section 2, which is the main section, correct? Answer, correct. Question. These proposed criteria sets are not intended for clinical use. Only the criteria sets and disorders in section 2 of the DSM-5 TR are officially recognized and can be used for clinical purposes. Isn't that what under Conditions for Further Study indicates? Answer, it does say that on page 903. Question, okay. Now, you testified that you didn't give any tests for malingering, correct? Answer, not correct. Question, okay, tell me what you did. Answer, I gave multiple tests that look at performance validity, multiple tests throughout the course of the day, both myself and Dr. Black. One end of the spectrum of performance validity testing outcomes would be assessing for malingering. Question, okay, so your tests were for effort, correct? Answer, correct. Question, okay. Are you saying that someone could not give good effort and malinger at the same time? Answer, if they're not giving good effort if they're giving such poor effort, that can end up with the determination that the person is malingering, yes. Question, all right. So if you give me, listen, Mr. Satz, I want to give you a test, and I do it rapidly. Give you numbers, count back from 100 by sevens. I can purposely give you false answers and still be giving you good effort, correct? Answer, a counting backwards test is not a performance validity test, but if they're giving poor effort on these performance validity tests, then that's indicating that they're not working hard. And potentially, at the extreme, they're attempting to malinger their testing that's going on at that time. Question. Okay, are you saying then, and I'll ask you the same question, you can't show good effort and purposely give false answers? Is that what you're saying? Answer, not on that performance validity test, no. Question, okay. Answer, if you're not giving good effort, it could be suggestive of malingering. Question, well, I'm saying if you are giving good effort and purposely giving wrong answers. Answer, the way that these performance validity tests are established and set up is that they need to give correct answers in order to assess for good effort. Question, okay, isn't it standard practice in a forensic evaluation, psychological or neuropsychological, to give malingering tests? Answer, as I do. Question, okay, you gave effort tests, right? Answer, I gave performance validity tests. Question, okay, and you're equating them with malingering tests, right? Answer, they can assess for malingering, yes. Question, okay, answer again. As I discussed yesterday, there are two types of validity testing. One is performance validity testing, and the other is symptom validity testing. Question, okay. Answer, because I'm doing neuropsychological testing. I'm looking at performance validity testing. Question, okay. Answer, I'm not worrying about whether he's endorsing psychotic features or things like that. I'm concerned as to whether he's working hard on these tests, so I give performance validity tests. Those tests do assess for potential malingering. Question, okay, so you're saying that you can't work hard to give bad answers, correct? Answer, he's got to get the answers correct in order to do well on these performance validity tests. Question, so you testified yesterday that the state's experts also gave effort tests, correct? Answer, that he also gave a performance validity test. Question, right. And didn't he also give a malingering test? Answer, he also gave a symptom validity test. Question, is that a malingering test? Answer, just like the performance validity test is, the symptom validity test can assess for malingering, but it's assessing for malingering of behavior and mental health issues. Question, okay, we'll have to fight with that. So let's go to this. I want to run this by you. Were you aware that to be accepted on the Marjorie Stoneman Douglas JROTC marksmanship team, that you have to fire 3 pellets in succession at a target the size of a quarter from 10 meters away? And if you're successful at hitting that target the size of a quarter from 10 meters away, 3 times in succession, then they give you a target the size of a nickel, and you have to hit the target with a rifle pellet gun, again, 3 times in succession from 10 meters away. And then, if you're successful at that, then they give you a target the size of a dime. And you have to hit the target the size of a dime 3 times in succession from 10 meters away. And 10 meters away is 32.81 feet, correct? That's almost 10 for basketball. Are you a basketball fan? Answer, not particularly. Question, okay, so I'll skip that then. I was going to tell you that the arc for the 3-point line is about 23 feet. This is almost another 10 feet, just for perspective and distance as to how far away 10 meters are. So were you aware of that? Answer, no. Question, okay. And then you have to learn precision sighting. Were you aware of that? Answer, no. Question, okay. And were you aware that the defendant in this case won a sharpshooter badge? Answer, no. Question, do you know what double tapping is? Answer, I have heard of it colloquially. Question, okay. So when you talk about visual spatial, doesn't that show good hand-eye coordination, the ability to be able to do that? Answer, no, not necessarily. Question, it doesn't? Answer, no. Question, okay. How about visual perception? Doesn't show that either? Answer, the ray complex does include visual perception, but it is perception of a complex information and being able to organize and recreate it. Question, yeah, I know, you told us that. I'm talking about what he did with the pellet gun. Answer, okay. Question, doesn't that show visual perception? Answer, that he's able to perceive a target. Question, hit it? Answer, I assume that he was asked to perceive the target. Question, all right. So when you talk about 1 standard deviation from the mean, and you told Mr. Secor yesterday, 84% of the population would do better, right? Answer, yes. Question, okay. So that means 16%, right, would be the 16th percentile. You know, how many people is that just in the United States? Answer, I am not going to be able to calculate that. Question, well, there's approximately 332,278,000 people in the United States of America alone, right? Would you agree? Answer, okay. Question, so that's over 53 million people would fall into that 16th percentile, correct? Answer, for 1 score. Question, well, 16th percentile is over 53 million people, right? Answer, I haven't done the math, so I will, I guess, have to take your word for that. Question, okay. Okay, so on page, talking about the graph, and it was my page 30 in your PowerPoint. It was your graph. Answer, okay. Question, okay. So let's talk about your graph. So you created, answer, would you like me to share that for you so we can all be seeing it at the same time? Question, we could, but I'm going to ask you things that aren't on the graph. If you want me to put it up, I will. Okay, so in the memory domain, you place, well, do you want me to put it up? Because I am going to ask you questions about it. So in the memory domain, you have 11 subtests, correct? Answer, yes. Question, okay, and you did not include on your graph 11 other scores for subtests that were in the average or above average range. Isn't that correct? Answer, I included the scores on this graph that are, and I published on, that are typically used in the assessment of FASD. Question, okay. Answer, I cannot put every single score or sub-item from every single test on a graph. It would be incomprehensible. Question, okay, but all the 11 I'm going to talk about were average or above average. So the California Verbal Learning Test Trial 2, the defendant scored in the 37th percentile. That's an average score, correct? Answer, and it's incorporated within the CVLT Learn score, which I can't point to. It's the very first dot within the memory scale. Question, okay. But the California Verbal Learning Test Trial 2 was not on your graph, was it? Answer, that's correct. Question, okay. And the California Verbal Learning Test Trial 3, where the defendant scored an average score, was not on your graph, correct? Answer, that's correct. It was included as a compilation score with the CVLT Learn, question right, answer, that first dot, question. And the California Verbal Learning Test Trial 4 was scored, but it's not on your graph, and the defendant scored an average score, correct? Answer, yes, question. And that was not on your graph. And the California Verbal Learning Test Trial 5, the defendant scored in the 25th percentile, and that's an average score, and that was not on your graph either, was it? Answer, it was, again, included within the CVLT Learn score. Question, okay. Answer, but no, it was not included independently. Question, okay. And each one of these subtests, doctor, tests something else, right? They test something different? Answer, each one of the subtests is a repetition of the list of words. So they're getting the list 5 times. Question, but they're given for a purpose and they're scored. Answer. And thus the overarching score for that learning portion is the CVLT learn, which was in the low average range overall. Question. And the California Verbal Learning Trial Test B, where the defendant scored in the 50th percentile, which is an average score, and that was not on your graph either, was it? Answer, that's correct. Question. And the California Verbal Learning Test Short Delay Cued Recall, the defendant scored, sorry? Answer, I'm sorry, you're breaking up a bit. I can't quite hear what you're saying. Question, okay, I'll be happy to repeat it. The California Verbal Learning Test Short Delay Cued Recall was scored, and the defendant scored in the 63rd percentile, which is an average score, and that was not on your graph, was it? Answer, that's correct, because I used the free recalls in the analysis. Question, okay, answer. And had been used for, question, okay, answer, 12 years now in the FASD analysis that I use. Question, and the California Verbal Learning Test Long Delay Cued Recall was scored. Answer, yes. Question, and the defendant scored in the 50th percentile, which is an average score, and that wasn't on your graph either, correct? Answer, that's correct. Question, and the California Verbal Learning Test Recognition was scored, and the defendant scored in the 84th percentile, which is an average score, and that wasn't on your graph either, correct? Answer, that's correct. Question, and going to the Wechsler Memory Scale Logical Memory Recognition, the defendant scored within the normal limits, correct? Answer, yes. Question, and that's an average score, and that was not on your graph. Answer, correct. No recognition scores were on the memory graph. Question, and the last answer, they haven't been. Question, go ahead, I'm sorry. All right. The Wechsler Memory Scale Visual Reproduction Recognition, the defendant scored within the normal limits, which is an average score, and that wasn't on your graph either, was it? Answer, correct. Question, okay. And the memory subtest of the Texas Functional Living Scale fell, the defendant scored in the 63rd percentile, which is an average score, and it wasn't on your graph, correct? Answer, it's incorporated into the Texas Verbal Learning Scale overall score. Question, okay. Let's go on to, that was the memory domain. So let's go to the attention domain, where you had 8 subtests, but you didn't include 5 subtests where the defendant scored in the average range, correct? Answer, well, he was scoring the average range on all of the subtests that were put on the graph as well. And there are these scores that are, again, typically included in all of my assessments when I'm looking at FASD as the primary scores for attention. Question, okay. So you administered, and I'm sure it's not related, Connor's continuous performance test, correct? Answer, that's correct, and no, it's not related. Question, right. And on the performance test, the defendant's HIT, hit reaction time block change subtest, the defendant scored in the high average range, correct? Answer, I'd have to look at the form again. Question, 85th percentile. Answer, okay, that's, question, high average range? Answer, what was that one for again? Sorry. Question, that was the continuous performance hit, the HIT or hit reaction time block change. Answer, it's HRT. Question, right. Answer, but it was, yeah, that would be about right for the percentile. Question, 85th percentile in the high average range, correct? Answer, yeah, 84th percentile, but yes. Question, okay, that's not on the graph? Answer, no. It never is on the graphs that I publish. I talk about them in reports when I do write reports. Question, okay. Answer, if they are relevant. Question, okay. The continuous performance test, subtest for detectability. The defendant scored in an average range, and that wasn't on your graph either, correct? Answer, that's correct. Question, and the continuous performance test, subtest of perseverations. The defendant scored in an average range, and that wasn't on your graph either, correct? Answer, that's correct. Question, and on the continuous performance subtest HRT reaction, interstimulus interval change, the defendant scored in the 73rd percentile, correct? Answer, yes. Question, and that's in the average range, and that was not on your graph either, correct? Answer, that's correct. Question, and the continuous performance subtest of HRT reaction time variability, the defendant scored in the average range, and that was not on your graph either, correct? Answer, that's correct. Question, okay, you can use and correct me if I'm wrong, Dr. Connor, you can also put the Connors continuous performance, some of their subtests in the executive function domain, correct? Answer, for most part, no, I wouldn't. It is a pretty solid attention test. Question, right. So my question is that you could have put, or you can tell me you wouldn't do it, the continuous performance subtest into the executive function domain. Answer, I wouldn't. Question, okay, but you can see where someone could. Is that what you're saying? Answer, there might be one score where you might be able to, but I still wouldn't, because that one score it says it's perseverations, but really it's hyper anticipation, responding too quickly. Question, okay, let's go to the executive function domain where you had 32 subtests, correct, that you put on the graph? Answer, I put 32 scores on the graph, yes. Question, and you didn't include 11 subtests that fell in the normal range, correct? Answer, I don't know what scores you're talking about. Question, okay, let's go over them. So before I get into those, you could also put the TOVA subtest under attention into executive function, correct? Answer, the TOVA is a pretty pure attention test. That's its primary goal, is to assess attention. Question, okay. So you could have also placed the TOVA subtest where he scored in the high average and average range in executive function domain, couldn't you? Answer, I would not. Question, okay, could you see where someone else could? Answer, somebody could do whatever they want, I guess, but I certainly would not. Question, okay, let's talk about the subtest. The Tower of London stimulus bound score, the defendant scored within the normal limits, correct? Answer, these are subscores, not subtests. Question, subscores. Answer, and by the emphasis of sub, meaning that they are not the primary scores within a test. Question, all right, whatever you want to call it. Answer, I need to look that up. Question, all right, go ahead. Answer, all right, please, can you repeat that for me? Question, sure. The Tower of London stimulus bound score, answer, correct, it was not in the graph. Question, an average scored in the average range? Answer, I believe so. Question, and not on the graph? Answer, that's correct. Question, okay, now, you also administered the Iowa gambling test, correct? Answer, correct. Question, and the Iowa gambling test is for decision making, correct? Answer, for rapid decision making and impulsive decision making. Question, okay, of planning? Answer, not particularly. Question, of impulse control? Answer, yes, in that kind of gambling type heated situation. Question, on judgment? Answer, for those sorts of decision makings, yes. Question, okay, so he performed well on the Iowa gambling test, correct? Answer, he did. Question, okay. Answer, and that's in the graph. Question, right. Okay, on the Iowa gambling test, net 1, the defendant scored in the 73rd percentile, which is in the average range, and that was not on the graph, correct? Answer, I only cite the total scores for that test. Question, okay, and on the Iowa gambling test, net 2, the defendant scored in the 45th percentile, which is in the average range, and that wasn't on your graph either, was it? Answer, that's correct. Question, and on the Iowa gambling test, net 3, the defendant scored in the 42nd percentile, which is in the average range, and that wasn't on your graph either, correct? Answer, that's correct. Question, and the Iowa gambling test, net 4, the defendant scored in the average range, correct? Answer, that's correct. Question, not on your graph, correct? Answer, that's correct. Question, and on the Iowa gambling test, net 5, the defendant scored in the average range, and that's not on your graph, correct? Answer, that's correct. It's all encompassed within the total score of the Iowa gambling test. Question, okay. Answer, which was in the normal range. Question, okay. But if you put all those average scores and above average scores, it would kind of mess up your percentages, right? Did you add them up? Answer, it would change that, yes. But again, as I say, these are the scores that I include in almost every single case that I do. Question, right. I'm sure. Answer, I don't include these sub-scores. Question, right, I'm sure that's exactly what you do. So you administered the Wisconsin card sorting test, correct? Answer, correct. Question, and isn't the Wisconsin's card sorting test a test of reasoning and problem solving? Answer, yes, it is. Question, and doesn't the Wisconsin's card sorting deal with concept formation and mental flexibility? Answer, yes, it does. Question, and wouldn't you agree that Wisconsin card sorting test is frequently used in fetal alcohol spectrum disorder to measure planning, problem solving, adaptability, and perseveration. Answer, and I wrote a paper on that. Question, so you agree? Answer, yes. Question, okay. You didn't place 5 Wisconsin card sorting subtests that scored all in the average range on your graph, right? Answer, again, not every single subscore gets put onto this graph as a matter of, question, right? Answer, standard protocol. Question, I think, okay. So on the Wisconsin card sorting total errors, the defendant scored in the average range, and that was not on your graph, correct? Answer, that's correct. Question, and on the Wisconsin card sorting perseverative errors was in the 68th percentile, which was in the average range, and that was not in your graph, correct? Answer, I'm sorry. You're going to have to say that one again. I apologize. Question, that's okay. I need practice. The Wisconsin card sorting perseverative error score, the defendant scored in the average range, and it's not on your graph, correct? Answer, that's correct. Question, and the Wisconsin card sorting categories completed was in the normal range, and the defendant scored in the average range, and that was not on your graph, correct? Answer, correct. And the Wisconsin card sorting failure to maintain set score was within normal limits, and the defendant scored in the average range, and that was not on your graph either, correct? Answer, that's correct. Question, and the Wisconsin card sorting learning to learn, where the defendant scored within the normal limits, which is the average range, was not on your graph either, correct? Answer, that's correct, and it never is. Question, Dr. Connor, would you agree that the Wisconsin card sorting test is used primarily to assess perseveration and abstract thinking? Answer, is to assess abstract thinking. Perseveration is one aspect that could be noted on the test. Question, okay, so do you agree? I'll read it again. Tell me what you disagree with. The Wisconsin card sorting is used primarily to assess perseveration and abstract thinking. Answer, it is used primarily to assess abstract thinking and reasoning. It can also assess, question, okay, answer, not primarily, necessarily, but can also assess perseveration. Question, when I use the word primarily, you disagree with it? Answer, the across the board for all aspects on all parts of the test, yes, I disagree with it. Question, and the Wisconsin card sorting test is also considered a measure of executive function because it's reported sensitivity to frontal lobe dysfunction. Do you agree or disagree with? Answer, I agree with that. Question, as such, the Wisconsin card sorting test allows you to assess your client's strategic planning, organized searching, and ability to use environmental feedback to shift cognitive sets, directed behavior towards achieving a goal, and modulate impulsive responding. Do you agree with that or disagree with it? Answer, it sounds like it's out of a document. Sounds reasonable. Question, okay, so you agree with it? Answer, sure. Question, okay. In reference to this case, you didn't read, well, you testified on direct that reading reports is very important to your evaluation, correct? Answer, reading prior evaluations, yes. Question, okay, all right. So it's just important to read prior evaluations? Answer, for the purposes of my involvement in this case, it was to assess for consistency with fetal alcohol spectrum disorder. Question, okay. Answer, in order to do that, I need to review prior records that assess and discuss cognitive functioning. So those records are important for me to review, yes. Answer, okay. Did you ask the defendant about the 17 murders he committed at Marjorie Stoneman Douglas High School on February the 14th, 2018? Answer, I did not. Question, sorry, Dr. Connor. Did you watch the 3 cell phone videos that the defendant made on February 8th and February 11th, 2018? Answer, I did not. Question, did you watch the Marjorie Stoneman Douglas school surveillance video of the defendant murdering 17 victims on February 14th, 2018? Answer, I believe I was shown a version of that. Question, okay, so you saw how purposeful his actions were? Answer, I watched the video. I was not doing it to interpret. Question, did you see how goal-directed he was? Answer, again, I was shown the video by defense so that I would be aware it occurred. And I wasn't watching it for interpretations of behavior. Question, all right. So you can't say whether he appeared on the video goal-directed. Answer, I have no opinion about that. Question, and dedicated to his task? Answer, I have no opinion about that. Question, have you viewed any of the defendant's social media? Answer, no, I have not. Question, have you read any police reports with reference to this case? Answer, no. Question, okay, isn't it true, Dr. Connor, that the best proof of what someone can do is what he actually does and has done? Answer, if you're trying to form a forensic opinion of a person's mental state at the time of an offense, yes, that's not what I'm being asked to do as part of this evaluation in this case. Your Honor, thank you. I have no further questions.
Yes, sir.
We didn't need to hear Denny answer the question that was asked.
You no longer need to hear Denny.
That's correct.
Okay. And you're all in agreement if you just raise your hand if you're in agreement with Mr. Benjamin. Okay. All right, thank you. So the bailiff will take you to the jury room to continue your deliberations. Okay, the jurors have been excused.
You're not right on the record here.
Are you gonna put something substantial? Okay, no, I'll go back.
She's not, she didn't sit down.
That's
yet.
okay.
Just give her a second. Okay, go ahead.
I just didn't hear the court, did the court say that the record reflected all 12 jurors have raised their hand?
I don't remember, but they did.
Okay, that's all I wanted.
I don't remember if I said that. Sorry.
That's okay. But that's the-
I know I checked, did a mental check, but I may not have said it. But for the record, all 12 jurors raised their hand that they were in agreement with the foreperson, Mr. Benjamin, indicating that the information that they were seeking was in the cross-examination, and that any questions that they may have had was answered in the cross-examination that was just read back, and that they no longer needed Dr. Denny's testimony.
Thank you.
Sure. Is there anything else?
No, ma'am.
Okay, we're in recess. You're always what does he do? Oh, well, yeah, that's true, both of you. Are present. The defendant is present. I intended to originally call you all here at around 5:15 to excuse the jury for the evening. But in the meantime, I received a question or a request that states, we would like to see the AR-15. Now, just to fill everyone in, after I instructed them that the gun would be sent back, but it was inoperable and the ammunition would not be sent back, I was informed by the sheriff's office that they do not want, for security reasons, even though it's inoperable, the firearm going back into the jury room. So I deferred to the sheriff's office, as they are in charge of security and those types of issues. So my suggestion would be, before I release the jurors for the evening, to bring them back in here, explain what I just explained to you, that I misspoke when I said I could send it back, and show them while they're in court the AR-15.
I would object to that. I think because they may want to examine it and talk about it themselves. So you can say, while you have the gun, we have to take the ammunition out of the room, and then when you're through with the gun, we can bring the ammunition back.
Okay, so this is above my pay grade. If you would please do me a favor, and Mr. Satz and a lawyer from the defense, if you can speak with the sheriff's office, maybe there's another case where you know it's been done, and you can convince them to allow that.
Judge, I can't tell you how many cases, and the gun has always gone back.
Okay.
I'll make a quick phone call.
Thank you. Do you want to, Mr. Satz, I'm not questioning you, but can you just give an example so they might know if something's...
Peppered, Ojan,
okay.
Any of them.
Okay.
Armstrong, was a Tech 9 went back.
Okay.
I mean, it always goes back.
Okay. Okay, so let's check. Thank you.
I'll be happy to talk to somebody.
Well, let's see.
You know, Ms. McNeil or whoever she...
I just contacted BSO Legal to, I'm sure they can short circuit this.
Okay. So, in those instances, you send it. I've had many cases with a firearm. I just don't remember whether or not the firearm has gone back. Certainly, I trust that you've had cases where it does. But I guess my question.
I've never had a case where it didn't.
Okay. Okay. So,
they're working on it right now.
So it's your position that if they agree, I can send it back. I don't need to just send it back for a certain period of time and then have the sheriff's office take custody of it. It can stay in the jury room overnight?
Yeah, yeah. And
That's your experience?
right.
Okay.
And if they say, well, we'd like to see the ammunition again, you can substitute the ammunition
Okay.
for the gun.
Okay. May I see two of the lawyers up at the bench, please? One from each side on this issue, please. sheriff's office has not been able to establish some kind of protocol for this, for the gun to go back. They can't get a hold of anyone on any of those trials that you described to ask what the procedure may be for doing that.
Okay, it's late, you can do it, obviously you can do whatever you want, but it's absolutely preposterous. The sheriff's office can't control what goes back to the jury room. What if it's a machete? Machete's more dangerous than a rifle without any bullets. You can't take a machete back because one of the jurors will have to pop one with another. I mean,
well,
a knife's more...
But Mr. Satz, they're in charge of security, and if they're telling me for security reasons that they need to take some measures before they allow it, I have to stay in my lane.
That's okay, but they're, and I'm not fighting with you, maybe I'm just spouting. You do what you feel you have to do, but they're jumping in your lane. You control what the jury sees, not the sheriff's office.
They're saying it's for security, and when they use that word, I defer to them. I think that they're going to go along with what you're saying. They just want to know the process by which it should take place.
I have no objection to that. I agree with you, no harm, no foul, but I'm just, it's ridiculous. That's all I'm saying.
I think they're aware of exactly how you feel, and they feel bad that they weren't more prepared for this. With that being said, I was going to excuse the jurors about this time. Captain Tianga assures me that this will be taken care of before the jurors return in the morning so that it can be waiting for them in the morning. Other than that, is there any reason why I can't excuse the jurors and have them retire for the evening?
Not a mistake, we got no problem.
Is either side asking for a special instruction or any instruction that I should give the jurors before they're dismissed? Other than what I've already given them?
I don't think it's necessary, Judge. You told them before.
I just, in the abundance of caution, I just want to make sure.
Yeah, as long as they know there's no deliberations outside the jury room.
Okay. And they do know that, and we have people that'll be watching them. So.
And Judge, what will be the procedure in the morning? Will they just be brought back to begin deliberations without reconvening court? We can agree to that procedure.
Sure. What is the preference of both sides?
Well, if they come back to the, I guess we'll have to figure out the procedure about the gun by the morning, because that's something that needs to be addressed, whether they go back to the jury room or come back to the box. That's something that has to be addressed.
Sure. I guess the problem is because it's 5:25, they can't get a hold of the legal department. They can't get a hold of anybody to give them some guidance on this. But I'd ask that be done first thing in the morning, and the sheriff's office first thing in the morning for them is like 6 o'clock or whatever time their shift starts. 7?
I'm sure it'll be worked on tonight.
It's going to be worked on tonight. So I see what you're saying. We need to address that first thing.
Yes.
Do you all know Charlotte? Convene. They should be here at 8:30. So we can reconvene it tomorrow at 8:30 to put the protocols for the gun on the record so that it can go right back with them when they get here.
Just the one thing I want to be careful about is, so they're going to be brought back here, and they're going to be put into the jury room, I assume, right away. They may feel they can just begin deliberations again, and that's fine with us, because that's what's going to happen. If they're all
Okay.
together and they're alone, they'll probably talk about the case.
Okay.
Which they should have permission to do.
Sure.
And, you know, I think we can address the gun early, but let them begin their deliberations, because they'll be sitting in the room and they're going to deliberate. Unless you keep them, you know, downstairs on the 3rd floor, and we don't want to do that.
Well, unless we meet earlier and resolve the gun issue before they get here.
Okay. I'm being told a more reasonable time to have them here is 9 o'clock. So if we meet at 8:30 and they get here at 9 o'clock, that should be sufficient.
Absolutely.
Now, if I hear from the sheriff's office tonight, I will be sure to email both sides to give you any update, and I imagine that this will be resolved by the morning because everyone's working on it. Okay?
Okay.
So for tonight, they're going to be excused. For tomorrow, we're going to meet at 8:30, and that way we'll have this issue taken care of before they get to the jury room. Okay, is there anything else?
No, Your Honor.
Thank you, Your Honor.
Thank you. All right, we're in recess until tomorrow morning.